Okay, we're streaming, and I believe someone has already activated the webinar.
Okay, thank you. So, Alan, on the record, please. Good morning. Today is the first day of remote evidentiary hearings conducted by the Energy Facilities Siting Board in docket EFSB 25-08. In this docket, Hillman Energy Center, who I will refer to as the company, has requested the Energy Facilities Siting Board, who I will refer to as the Siting Board, grant individual and comprehensive zoning exemptions from the Tewksbury zoning bylaws for proposed battery energy storage project located at 73 and 75 Hillman Street in Tewksbury. The project includes the battery energy storage system, a project substation, and related interconnection line that I will collectively refer to as the project. My name is Donna Sharkey. I am the presiding officer in this proceeding. We are conducting this evidentiary hearing remotely using Zoom video conferencing. This hearing is being recorded and will be available for viewing on YouTube. The official transcript of the proceedings is being transcribed by the stenographer appointed by the board for that purpose. The stenographer is also participating remotely. He will transcribe everything said during this hearing. As we are relying on the internet, or occasionally people will participate by telephone to participate, we could experience some technical difficulties, including sound from speakers, background noise, video and audio issues, and sound lag. These possible technical issues make it especially important to speak slowly and clearly, to allow a speaker to finish speaking before you begin speaking, and to pay attention to your video screen. If I need to interrupt a witness, I may raise my hand as a signal on my video for them to stop speaking. Please look for my hand and stop speaking immediately if you see it raised. Please also mute your audio whenever you are not speaking to reduce background noise. We appreciate everyone's cooperation in participating in this hearing. As you can see on your Zoom video stream, there are several other people from the board who are participating in our virtual bench today. I'll ask that they raise their hand in their Zoom window when I identify them. Andy Green, Director of the Siting Division. Joan Foster Evans, the General Counsel of the Siting Division. Wayne Wong, Assistant Director of the Siting Division. And two analysts with the Siting Division, Tim Riley and Nathaniel Strasberg. In this proceeding, pursuant to General Law, Chapter 40A, Section 3, we will review the petitioner's request to determine whether to exempt the project from zoning requirements of the town of Tewksbury, based on whether the present or proposed use of the land or structures is reasonably necessary for the convenience or welfare of the public. The petitioners are seeking both individual and comprehensive zoning exemptions for the construction and operation of the project. Next, I'd like to ask the council and legal representatives who are online now identify themselves for the record. Mr. Kaplan, would you like to start?
Yes, thank you, Madam Presiding Officer. On behalf of Hillman Energy Center, LLC, Andrew Kaplan, Eben Albert, Nicholas Salaleco with Pierce Atwood, 100 Summer Street, Boston, Mass.
Mr. Senni?
Yes, good morning. Thank you. My name is Christopher Senni. I represent interveners Maureen De Palma and Dennis Sheehan in this matter.
Thank you. Mr. Bernstein?
Thank you, Madam Presiding Officer. My name is Jeffrey Bernstein, BCK Law, P.O. Box 205, Woodstock, Vermont. I represent the town of Tewksbury.
And Ms. Gillis.
Shannon Gillis, Tewksbury Health Director. I represent the Tewksbury Board of Health.
Thank you. As a preliminary matter, I would like to resolve any remaining issues regarding the availability of witnesses and the hearing days at which specific witnesses will be available to testify. In addition, we can discuss the timing of further discovery for pre-filed testimony and other materials that may have been filed last week, and the timing of questioning for those materials as well, including the town's pre-filed testimony and the company's stormwater report from Langen. Alan, can we go off the record, please? Okay, so this is our first opportunity to have all the counsel for the different parties online at the same time. And we have a number of issues to resolve with regard to the schedule. I'd like to, if we can start with witnesses that are scheduled by Mr. Senni for the De Palma Sheehan party, and their availability for days next week, which is not uninterrupted during the course of the 4 days of that week. We cannot have hearings on Monday, which is a state holiday, but we do intend to have hearings the rest of that week to the extent needed to complete questioning for witnesses. So, Mr. Senni, if you can lay out the days in which your witnesses are available, maybe you could start with the witnesses with the most restricted availability, and then we can check with counsel who may have questions for those witnesses so we can try and establish the best days for them to testify.
Yes, thank you, Madam Presiding Officer. I had submitted a schedule of the suggested appearance dates and times for our 4 witnesses. I suggested that on Tuesday, February 17th, in the early morning session, we would make available George Melham of IO Mosaic. He is the witness who has prepared our dispersion analysis, and he is available at that first thing in the morning session on the 17th. In the mid-morning, provided we can finish with Mr. Melham quickly enough, I have our stormwater management expert, Scott Horsley, available. And then if time allows, in the mid-afternoon, our fire safety expert, Milos Pachowski, is available. Except for George in the morning, Mr. Horsley and Mr. Pachowski have some flexibility on start time, and even if their testimony had to be shifted to another day. I then suggested that 2 other experts from IO Mosaic on fire safety could testify in the early morning session on Wednesday, the 18th. That would be David Blake and James Close. As you know, the company IO Mosaic was retained by my clients, and there are 3 experts from IO Mosaic. Mr. Melham, who would be available on Tuesday the 17th, is one of them, and then Mr. Blake and Mr. Close are the other 2. Then I suggested in the mid-morning session, our noise expert, Corey Nickchin, would be available. Again, that's on the 18th. And then I included in the afternoon, in case Mr. Pachowski is not reached on the 17th, he could be available for testimony on the 18th. So that's the full extent of our witnesses. We basically have 4. We have Mr. Pachowski, Mr. Nick Chin on noise, Scott Horsley on stormwater. And then in terms of fire safety, we have 3 potential witnesses from IO Mosaic. Again, there is some flexibility, but our witnesses are available the week of the 16th, although I know that the 16th itself is not a hearing day. And I expect to be able to work with the board in the event that things take longer than expected, and my witnesses are committed to helping with that process.
Thank you, Mr. Senni. Can I ask you if there is flexibility with regard to the IO Mosaic witnesses? I know it appears that the most senior witness, is it Mr. Mulhern?
Yes.
Has the most limited availability. To what extent would the other 2 witnesses from IO Mosaic adopt or provide testimony in his stead if we run out of time, for example, in terms of questioning for him?
Well, they can, but we prefer to have Mr. Melham testify, which is why I put him first in the morning on the 17th. That's when he's available, and it is a high priority for us to have him testify. But he has worked very closely with David Blake and James Close, and if necessary, they can testify on the air dispersion model. But since Mr. Melham really created and supervised that model, I think his testimony would be very valuable.
So then let me ask, initially, at least the company who I would assume might have the greatest number of questions for Mr. Senni's witnesses, in particular, the IO Mosaic witnesses. If they have an estimate at this point of the length of time it might take to do that questioning, which I am strictly asking for in terms of trying to schedule the timing for that witness, those witnesses.
We believe at this point, we would be able to meet Mr. Senni's schedule.
Okay.
In terms of the questions that we have for those witnesses. We have more questions for some, less for others. So I can figure that out as we get a little bit closer as this couple of days goes by, and maybe narrow down the time. But as far as the 17th and 18th, we're okay with that.
Okay. Mr. Bernstein?
If the town has cross at all for Mr. Senni's witnesses, it would be extremely limited, but there may not be any.
Okay. Thank you. I appreciate that.
Yep.
Ms. Gillis?
That schedule works for me.
Okay. With regard to the 3rd week, which is when I anticipate we will start with the town's witnesses. I believe Mr. Senni has requested, in addition to the dates scheduled for the town's witnesses, to question the company's fire safety witness after the town's witnesses have testified. Is that acceptable to the company?
So I have to admit, I'm not sure I completely understood that one.
So the plan is that Mr. Senni can talk to it, but I believe he's asked to have his cross-examination of the company's fire safety witnesses after the town's witness on fire safety has testified the beginning of the 3rd week.
Okay, so that would be like the 23rd-ish?
Depending on how long the cross-examination goes for the town manager and and the town's fire safety witness.
Okay, so Chief Morris is available on the 24th, but not the 23rd.
Which would, that would seem like that would work within the constraints for that week.
It would.
Mr. Bernstein, do you have any?
Well, the town manager, I would anticipate, maybe incorrectly, that between the bench and the other parties that there wouldn't be extensive cross-examination, but obviously not asking anyone to, having just gotten the testimony last Friday, to commit on that. I don't really have a strong feeling about the order. Mr. Hayes has extremely limited availability that week, but his colleagues, Mr. Nicholas and Mr. Casper, are prepared to adopt his testimony and testify as a panel, and they're available 23rd, 24th, 25th, though they requested that I let them know sooner as opposed to later which day or days that they should reserve on their calendars. Mr. Hayes is chairing a committee meeting I think in California, and he's tied up starting at 11 o'clock East Coast time, which, whether it's worth him joining for 45 minutes or an hour, I leave up to the presiding officer. But
So in addition to the scheduling for those witnesses, we also have the questions with regard to the ability of parties to do some discovery on the testimony that was filed last Friday. I'd like the company, Mr. Senni, and potentially Ms. Gillis to weigh in on that.
Company has no questions on the pre-filed testimony of the town.
Mr. Senni?
Yes. We will have a few limited questions for the town's witnesses. And I can have those prepared by Friday. Also, if I might just clarify my request with regard to not crossing witnesses until the week of the 23rd. As you know, we received recently several different types of new evidence related to safety. Very recently, the hazard mitigation analysis, the emergency response plan, a new 9450A test result, and the town's fire experts or safety experts testimony. I need time to get input from my experts in order to be able to cross-examine any witnesses on safety. In other words, I don't object at all to the company putting on its case this week, including fire safety experts. I just don't want to have to cross-examine those witnesses on safety until I've received input from my witnesses on the whole body of the evidence and testimony on safety. The other request I have concerns stormwater management. As you know, we recently received a revised storm management report. I have Mr. Horsley looking at that. I'm not prepared to cross-examine the company's witness on stormwater management this week. And I would suggest that that should also be deferred so that we have time to adjust to this later filed testimony. Again, I have no objection to the company putting on their case in whatever order they would like, but I would like to defer my cross-examination until I've had time to digest all this new information. But in terms of your specific question, yes, we will have some discovery questions for the town on their recently filed testimony, and I can have that done on Friday.
If Mr. Senni provides those questions to you, Mr. Bernstein, on Friday, can you tell me what, I know you haven't seen them yet, but what the potential turnaround time would be for those?
I'll do my very best to turn them around by the following Friday, given that, Monday is a holiday for some people. And if I can turn them around earlier, and I didn't know if the board might have any questions as well. Obviously, I want to see the entire universe of questions to the extent they might be duplicative so that we can answer them as efficiently as possible. But we certainly, again, based on what Mr. Senni has described as a fairly limited expectation right now, we certainly could turn them around by the following Friday.
Ms. Gillis?
At this time, we don't have any questions, but if an issue arises that we would need clarification, then we would ask if we could ask questions.
This is more just specifically with regard to potential discovery or questions based on what was recently provided so that you would have them in advance of them actually appearing on the stand that third week. That's all.
Okay, we have none.
Okay. I anticipate that there may be questions that the staff would have in addition to perhaps the normal follow-up we might have after Mr. Senni asks questions of the fire safety witnesses. I expect we may have additional questions that we would like to ask regarding the most recent stormwater materials that the company provided, and that we would do that questioning the third week at the same time that those witnesses come back to provide responses to Mr. Senni's questions.
That's right, and potentially some 95-48 questions as well.
Thank you, Mr. Riley. So at that point, is there anything else that we need to discuss in terms of scheduling? Mr. Senni?
I wonder if it's possible to get a list of the company's expert witnesses and the subjects they're going to testify on. That may become academic quickly if the company is presenting its case today. But I am confused in terms of the names of different witnesses from the different engineering firms as to who is testifying to what subject. And it would be helpful if we could have that list.
Not to speak on behalf of the company, but it's my understanding they intend to do some very limited initial direct
Correct.
when the panel is sworn in today, which would provide that information. Is that correct, Mr. Kaplan?
That is correct.
Mr. Senni?
Yes.
If I could impose on you yet again, could you send an email which formalizes the order of the availability of your witnesses yet again? I apologize, for that second week.
Yes, I can.
And just circulate that around again to the service list.
Yes.
And I will send it to Mr. Brock as well.
Yes.
So do I understand that we're back after this week? It would probably be the 17th, 18th, and the 24th so far? Is that
So it would be all 4 days next week other than Monday.
okay?
And then 4 days that week of March 23rd, but for the Thursday, because there is a siting board meeting scheduled on that Thursday.
Yes, okay.
You mean March 23rd or February 23rd?
February 23rd. Anything else while we're off the record?
sorry, one more clarification. So the 17th and 18th, I know that some of our witnesses are not available on the 19th and 20th. And so does it look like we have to be there on the 19th and 20th, or are we hoping to get through this on the 17th and 18th, the 19th and 20th, just in case we don't?
I mean, basically I've reserved, all 4 days that week. If we don't need all of them, we won't use them. But, you know, I think it's unclear at this point, exactly how long the questioning can take. And also, as I know you're aware, as you're proceeding through a hearing, even the best of estimates can be off. And people may end up being on the stand longer than perhaps the presiding officer or the counsel for the parties may have anticipated.
Is Mr. Nickchen available on, he is available Tuesday, right, for noise?
I think that's a question to Mr. Sunny.
Sorry,
Yes.
could you repeat that? I didn't hear it.
Oh, yes, for your noise specialist, we'd like to try to get through him on the 18th, is that? The 17th, is he available on the 17th?
Yes, he could be if that would be preferable. I put him on the 18th, but he could also be on the 17th.
But I think in part what we're wondering is it's at least conceivable we could get through your other witnesses on the 17th. And if we did and still had time left over, whether Mr. Nickchen was available that day as well. It sounds like he potentially is.
He could be, as long as he has enough advance notice. He could be available on the 17th if it goes quickly.
Thank you.
And my expectation is that in the order of questioning for Mr. Senny's witnesses, we would start with questioning from the company, then proceed to questions from staff, then proceed to questions from Mr. Bernstein, if any, and then proceed to questions from Ms. Gillis.
Thank you.
Last call before we go back on the record. Okay, back on the record. We've had a extended discussion off the record with regard to the availability of witnesses for what is currently anticipated to be the second and third week of hearings in this particular docket, as well as the availability of discovery and discovery responses for the town's witnesses related to the pre-filed testimony that was filed on last Friday, and potentially with regard to stormwater information that was filed by the company on Friday. If there are discovery questions that are going to be asked on those topics, those questions should be asked by this coming Friday. The town will provide responses by the next Friday. And thus those responses will be available before those witnesses testify for the third week of hearings. Does that capture everything that we discussed off the record?
Yes.
So moving on. I note that while there are several discovery responses that are the subject of a motion to compel, I believe that we have received all discovery responses from all parties to date. Is that correct? I
I think
realize
so.
council may not be happy with the quality of the responses provided, but just to the extent that all those responses have been provided.
Yes.
Thank you, Mr. Senni. Mr. Kaplan?
Yes.
Okay. Okay, I would like to note that we currently have two motions before us for which I have not yet issued a ruling. A January 23rd motion to compel from Mr. Senni, as well as a January 13th motion for partial summary judgment also from Mr. Senni. I would like to turn first to the motion to compel filed by Mr. Senni of January 23rd, 2026 to the company regarding outstanding or responses that were provided to his discovery requests and the company's January 30th response. Have the visual renderings that Mr. Senni requested in his discovery responses been provided on February 2nd as noticed in the company's cover letter to the response to the motion to compel?
Yes, we have received those renderings. So items 1 and 2 in the motion to compel can be withdrawn, or I can note that they've been satisfied.
That's fine. Thank you, Mr. Senni. So next I'd like to turn to the questions related to the site selection process, particularly with regard to interconnection options for alternative sites and the costs associated with interconnection from different sites considered by the company. I would like the council to address those issues and briefly recap them in oral argument. However, in order to give both Mr. Senni and Mr. Kaplan some time to think about that, I'd like to schedule that for immediately after we come back from our lunch break today. And at that time, the council should also address the remaining issue of the question related to the cost of the project site.
Thank you.
Are there any other issues related to objections to discovery requests that have not been reduced to writing in motions that we should address now? Mr. Senni?
Yes, there are two reports that were done for the company, one by a company called Exponent and the other by a company called Hazard Dynamics. And those were dated back in October. And I don't know if the company intends to have the authors of those studies testify. I have not seen indications that those authors are available, and I would like some clarification on that.
Dr. Kotz will be testifying on behalf of Exponent, and we have Chief Morris, who can testify on behalf of the Hazard Dynamics report.
And those two witnesses for Hazard are with that company?
No,
So they are not the authors of that study.
correct.
Is it possible to make available the authors of that study.
Let me give that some thought and see if I can check in with them, but I can't answer that right now.
Okay, so I'd appreciate if perhaps when we are not actually in the hearing, Mr. Senni and Mr. Kaplan can discuss that topic and then come back to me with whatever the result of that discussion is. I believe there's one more issue related to the schedule, which is the schedule for Mr. Cotz's testimony, who provides testimony on EMF on behalf of the company. The company has requested that if possible, Mr. Kotz could testify on Friday of this week. Since it's a somewhat severable topic with regard to the project, would that be acceptable to Mr. Senni, Mr. Bernstein, and Ms. Gillis?
It's acceptable to me. That's fine.
No concerns at Townsend. I don't think we'll cross Mr. Cott in any case.
Thank you, Mr. Bernstein. Ms. Gillis?
It's fine with me.
Okay, thank you. Okay, next is the motion for partial summary judgment filed on January 13th, 2026 by Mr. Senni, and the January 27th responses filed by the company and the Board of Health, and Mr. Senni's February 3rd, 2026 response to those responses to his motion. I am not going to rule at this time on the legal arguments presented in Mr. Senni's motion. The legal analyses not related to Mr. Senni's jurisdictional arguments that are presented in the submission by the Tewksbury Board of Health or the January 27th response filed by the company. I would note that all of these filings contain a mix of legal and factual disputes, and I expect the factual matters to be examined during these evidentiary hearings and presented by the parties in their briefs in this proceeding. Our review of the legal arguments advanced by the parties on a variety of topics in these motions is still under consideration at this time. Are there any other procedural matters to address at this time?
I don't think so.
Okay, counsel, go ahead.
No, I said none for the company.
Oh, thank you. Counsel for the company provided a draft exhibit list by email to the council and legal representatives for use during the hearings. At the end of the evidentiary hearings, I will move all exhibits identified on the updated exhibit list, which will reflect additional documents, including supplemental or revised information responses, record request responses, and any additional exhibits introduced in the hearing, to the extent the exhibit is not excluded, into the record of this matter. Prior to moving the exhibits into the record, I will provide an opportunity for objections to particular exhibits. At this time, would the company's counsel like to present its witnesses, and then I will swear them in?
Yes, thank you, Madam Presiding Officer. Start this morning, we have Tyler Wren. Mr. Wren, please state your name, your title, and your business address for the record.
I'm Tyler Wren, project developer at Eastpoint Energy, the parent company.
Sorry, Mr. Wren, you're going to need to speak up a little more, please.
Sorry.
A little slower, please.
My name is Tyler Wren. I'm the lead project developer on the Home and Energy Center project. My business address is 310 4th Street, Northeast, Charlottesville, Virginia, 22902.
Mr. Rin, would you raise your right hand so it's visible in the screen? Do you solemnly swear to tell the truth in this proceeding?
I do.
Thank you.
Mr. Rin, was your pre-filed testimony, the related documents, and any responses to discovery where you are listed as the witness prepared by you or under your direct supervision and control?
Yes.
And can you tell us just the overall topics of those?
Site selection, project development processes, and operations.
Do you have any changes that you would like to discuss or bring to the record now for any of those, the information that's been provided?
No.
Thank you. Mr. Bergeron, can you please state your name, your title, and your business address for the record?
Good morning. My name is Mark Bergeron. I am a managing principal with Epsilon Associates. My business address is 3 Mill and Main Place, Suite 250, Maynard, Massachusetts, 01754.
Can you tell us the topics that you'll be serving as subject matter expert on?
Yes.
Why don't you just let me swear him in and then he
Oh,
can.
I'm sorry.
That's okay. Mr. Bergeron, thank you for raising your right hand. Do you solemnly swear to tell the truth in this proceeding?
I do.
Thank you.
Mr. Holmes. Oh, I'm sorry, Mr. Bergeron. Can you tell us the topics of discussion that you are serving as subject matter expertise to?
Yes. Some regards to site selection, water and wetlands, and stormwater as it relates to wetlands.
Was your pre-filed testimony, the related documents, and any responses to discovery where you were listed as the witness prepared by you or under your direct supervision and control?
Yes.
Do you have any changes to any of those, any of that information?
No.
Thank you. Mr. Holmes, could you please state your name, your title, and your business address for the record?
Yes, I'm Frank Holmes, and I'm a principal and civil engineer with Langen Engineering and Environmental Services. And our business address is 100 Cambridge Street, Suite 1310, Boston, Massachusetts, 02114.
Mr. Holmes, can you raise your right hand so it's visible in the video screen, please? Do you solemnly swear to tell the truth in this proceeding?
I do.
Mr. Holmes, can you tell us what your topics are for as subject matter expertise in this matter?
My topics are site, civil engineering, design, and stormwater management.
Was your pre-filed testimony, the related documents, and any responses to discovery where you were listed as the witness prepared by you or under your direct supervision and control?
Yes, they were.
Do you have any changes to any of those documents?
No, I don't.
Thank you. Chief Sean Morris, please state your name, your title, and your business address for the record.
My name is Sean Morris. I'm a senior consultant with the Energy Safety Response Group, ESRG. Business address is P.O. Box 12639, Columbus, Ohio, 43212.
Mr. Morris, can you raise your right hand so it's visible in the video screen? Do you solemnly swear to tell the truth in this proceeding?
I do.
Thank you.
Chief Morris, what is the topic of discussions that you will be serving as subject matter expertise?
Fire and life safety.
And was the documents that had been provided to the EFSB, any responses to discovery where you were listed as the witness, were they prepared by you or under your direct supervision and control?
Yes.
Do you have any changes to any of those documents?
I do not.
Mr. Callahan, please state your name, your title, and your business address for the record.
My name is Ryan Callahan. I am the acoustics group lead at Epsilon Associates in Maynard, Massachusetts. The address is 3 Mill and Main Place, Suite 250, and the zip code is 01754.
Mr. Callahan, can you raise your right hand so it's visible in the video screen? Do you solemnly swear to tell the truth in this proceeding?
Yes.
Thank you.
Mr. Callahan, what is your area that you'll be discussing as your subject matter expertise in this matter?
Acoustics.
And was your pre-filed testimony, the related documents, and any responses to discovery where you were listed as the witness prepared by you or under your direct supervision and control?
Yes.
Do you have any changes to any of those documents?
No.
That is the panel for the company, and they are ready for cross-examination.
Thank you. I just want to double
Oh, I'm
check.
sorry. I don't know if Dr. Kotz is still on or if we're going to just do him on Friday.
We can do them now or we can do them on Friday, whichever is better for you. Mr. Kotz, you're on, so why don't we swear you in? Do you want to introduce him, Mr. Kaplan?
Sure. Dr. Kotz, please state your name, your title, and your business address for the record.
My name is Benjamin Kotz. I'm a principal engineer with Exponent. My business address is 17,000 Science Drive, Bowie, Maryland, and the zip code is 20715.
Dr. Kotz, could you raise your right hand so it's visible in your video screen? Do you solemnly swear to tell the truth in this proceeding?
I do.
Thank you.
Dr. Kotz, what is your area of expertise that you will be testifying on in this matter?
I will be discussing the electromagnetic fields as it pertains to the project.
Was your pre-filed testimony, the related documents, and any responses to discovery where you were listed as the witness prepared by you or under your direct supervision and control?
Yes.
Do you have any changes to any of those documents?
I do not.
Now the panel is complete and is ready for cross-examination.
Thank you. All the witnesses that you've presented today are now under oath. Dr. Kotz, I look forward to seeing you again on Friday morning.
Thank you very much.
Mr. Kaplan, do you have any additional direct examination of your witnesses?
I do not.
Okay. So we will start with questions from the siting board staff. We will then proceed with questions from Mr. Senni, Mr. Bernstein, and Ms. Gillis. At the conclusion of questioning by the staff and the interveners, there will be an opportunity for redirect examination by the company, although of course that will be chopped up somewhat in view of the fact that some of the witnesses will be returning at later stages, such as week 3 in this particular proceeding. Let's take a 5-minute break and we will start with questions from the bench. Off the record. Back on the record?
Just one moment, please. Thank you.
So I'm actually going to start on behalf of the staff with questions for Mr. Ryan. So to start with, I'd like to point you to the company's December 4th supplemental filing and begin by reviewing the changes between the company's initial April filing and the materials submitted in the supplemental filing. Do you have a copy of the company's December 4th filing available to you?
Give me one moment, please. I do.
Okay. So please turn to the cover letter, which was signed by your counsel, which I circulated by email and am going to mark for identification purposes as EFSB-1. All the parties should have copies of that by the email that I circulated last week. In this letter, there is a description of the changes presented in the supplemental filing. I tried to find another document which provided a summary of the changes presented for our review. Could you point me to a document submitted elsewhere in the record so far which provides that information in summary form?
A summary of the changes?
Yes. I tried to find one going through the record, but I did not find one, which is why I asked to have the cover letter marked for identification purposes.
I believe we summarized a lot of that in a response to Mr. Senni's request, but we can also provide a red line copy if you'd like.
Okay, well, since I've already marked it, let's walk through the cover letter, which I need to confirm with you since it's a letter from counsel and it's not otherwise testimony in this proceeding.
Yeah, that's fine.
Okay. Now, in the letter, it states that the company has provided a supplemental 30% design plan prepared by Langen, which was attachment A to this supplemental filing. Is that correct?
Correct.
And it notes two modifications that differ from the original filing. The first was a redesign by the company of its stormwater system at the request of the town of Tewksbury.
Yes.
Could you provide some additional detail on that change and the discussions with the town of Tewksbury?
Sure. We had shown the town our preliminary 30% design of the stormwater system, and upon their review, they informed us that one of our discharge points in continuing the existing flow of the site's stormwater system into the town's stormwater system would not be allowed. So we changed the design to discontinue that connection to the town system.
Okay, the second change that's noted in the letter is that the company added a gravel parking pad on the property. Can you tell me, was that also at the request of the town, or was it for ease of parking during construction or operation and just had not previously been included?
Yes, that was a design change intended to add slightly more parking for construction and operations at the request of our operations group.
And in addition, the company discusses next the determination to change the battery manufacturers for the batteries to be used at the project, and to switch to batteries designed by Lithium. Is that correct?
Yes.
In the letter, it provides that the company made the change because the manufacturer was more open to providing public information than other battery manufacturers. Is that correct?
Yes.
Were there other reasons for selecting the lithium battery design?
No.
I'm sorry, I didn't hear the end of the question. Were there other reasons for selecting the lithium battery? What?
Design.
Thank you. I got the answer.
With the change, it appears that the company provided updated information to include the lithium battery modules in reports provided with regard to sound, to EMF, as well as a number of other attachments and updated visual information that were being provided. Is that correct?
Yes.
So can you briefly address, and please understand you will be getting more questions and more depth on each of these different topic areas, but could you briefly describe how the change in the battery design and the new site design in terms of the location of the batteries caused changes in the noise levels expected to be produced at the proposed site?
Yeah, the battery containers had a different sound profile than the existing or the original batteries we had proposed. And therefore we conducted an updated sound model to reflect that change.
Was there an improvement in the projected noise levels related to the change in the design of the battery and the placement of the different battery modules?
This is Ryan Callahan speaking. There was not an improvement. It was essentially the same result as the result of the redesign, which included a change in the battery equipment, but also included a change in the height and location of the proposed sound barrier walls.
So are you saying that the company's change in noise mitigation, such as the sound walls, were included as part of the noise modeling that were filed on December 4th?
There was a revised acoustic modeling assessment that was done for the redesign. And that was filed with the supplemental testimony.
And I'd also like to ask if Mr. Ryan could discuss generally, although you can defer questions to Dr. Kotz if necessary, the extent to which there were changes in the potential electric and magnetic fields related to the new design and revised module placement.
There is no change to Ben Cott's report.
I'm sorry, there is no change. What?
To Dr. Cotz's report.
Is it the company's position that there has been an improvement in the potential environmental impacts related to the project redesign?
No.
Are potential environmental impacts worsened by the change in design?
No.
So your testimony is that the changes produce essentially overall the same environmental impacts as the initial design presented in the original petition?
Yes.
So if I could turn to your response to G-4, EFSB G-4.
Yes.
In that response, you noted that what's normally referred to as a pilot agreement, as in a payment in lieu of tax agreement, was being negotiated with the town. Do you contemplate a separate pilot agreement in addition to the HCA, which was provided with the town manager's pre-filed testimony?
Yes.
Is that agreement concluded as of yet?
That agreement is still under discussion and negotiations with the town.
Okay, if you could turn to the original petition submitted in April by the company. Could you please turn to page 39 of the petition? In this section of the petition, you discuss state statutes and policies as they relate to the project. Do you have any updates to provide with regard to this section since its filing last April?
No.
Okay, could we turn to your response to EFSB G-11? In that information request, we asked about the 2024 Climate Act, and you responded that the regulations had not yet been adopted. Can you tell me your understanding of the goals of the 2024 Climate Act? You may find it helpful to look at responses to EFSB G3 and N2.
My understanding of the 2024 Climate Act was to set a target and goal for Massachusetts in terms of best procurement and battery storage on the grid within Massachusetts, which includes a 500 megawatt target by 2030. It also established statewide procurements for energy storage and set out other goals regarding clean energy.
So in your response to EFSB N-4, you identify a number of project characteristics which advance the energy goals of the Commonwealth. And if you could turn to that response.
You said M4?
N4 as in need.
Yes, I have it.
So in that response, there are a number of project characteristics related to peak shaving, peak shifting, system resilience, renewable intermittency mitigation, ancillary services, capacity supply, and other capabilities that are project characteristics that advance the energy goals of the Commonwealth. Is that correct?
Yes.
And would that express your understanding of the extent to which the project assists in meeting the goals of the 2024 Climate Act?
Yes.
So also in the 2024 Climate Act, the legislation adopted new language in General Laws, Chapters 164, Section 69H, which identifies a number of environmental and public health concerns to be considered in evaluating clean energy infrastructure projects. Could you tell us if in connection with your project, how your project mitigates or minimizes environmental impacts?
The project adheres to the state stormwater policies and other general design practice that minimizes impacts, both with sound and visual impacts as well being mitigated through sound barriers and other mitigation measures. There's also no emissions during operations from a project.
Does the project minimize negative public health impacts?
Yes.
Does it support labor interests?
Yes.
Does it address economic justice?
Yes.
Environmental justice and equity?
Yes.
Public health and safety?
Yes.
And does it include consideration of policies related to reducing cumulative burdens in the community?
Yes.
I'd like you to refer you to EFSB G-18 and the attachment that describes various site plan changes.
Yes.
Did the change in the batteries and the site layout change the planned interconnection facilities as originally portrayed in the initial petition?
No.
Can you generally describe the differences between the initial battery manufacturer that you had selected and the lithium battery design in a general way?
Yeah. Overall, very minor changes. Essentially, it's just a different manufacturer of the batteries. The sizing and the size of each container is roughly the same. The weight is all the same from a general perspective.
Is the reduction in the number of inverters related to the reduction in the number of battery modules?
Yes.
Now, we already discussed that the company's filing had stated the change in manufacturers allowed the company more flexibility in providing information related to battery testing for safety. Did the change also allow you to provide more information on product characteristics such as noise, EMF, and emissions?
In regards to noise, yes.
With regard to EMF?
There was no change between the two.
Was there a change in emissions?
In terms of emissions, there are no emissions. From a fire safety perspective, it allowed us to submit more robust documentation of the testing.
So, Mr. Bergeron, in your pre-filed testimony, you had stated that the project as proposed did not trigger any MEPA thresholds requiring a MEPA filing or review. Does the project as presented in the December 4th supplemental filing include any changes that would require a MEPA review?
It does not. MEPA review is still not required for the changed project submitted in December.
And then attachment E of the petition included of the initial petition included correspondence with the Massachusetts Historical Commission and the project notification form materials for the project. Has the company received any subsequent communications from the MHC or from the Tribal Historic Preservation Offices of the Mashpee Wampanoag Tribe, the Wampanoag Tribe of Gayhead, the Narragansett Indian Tribe, the Massachusetts Commission on Indian Affairs, and the Tewksbury Historical Commission related to the project?
We have received additional communication via email from the Massachusetts Historic Commission regarding our project notification form, which is attachment E that you're referring to.
Yes.
In that email, and I don't have the date, I do in front of me or off the top of my head, they indicated that they have no concerns. They've reviewed our PNF and have no additional requirements for additional studies related to historic or cultural resources. We have not received any communication from any of the other parties mentioned in your question.
Would the December 4th supplemental filing change any of the information presented in the original PNF regarding the cultural resources sensitivity assessment?
It would not. That sensitivity assessment speaks to the entire project site that encompasses the project.
Is the company required to submit an updated PNF to the MHC?
We are not, because MHC reviewed and considered the potential for development on the entire project site in their response to us.
So the changes with regard to the location of anything from stormwater facilities or battery modules do not impact the original assessment. Is that correct?
That's correct.
Okay, thank you, Mr. Bergeron. I believe we are now moving to questioning from other members of the bench.
Thank you. First set of questions address construction and outreach. Refer to the initial petition at 1. What are the positions of National Grid and the MBTA on crossing the proposed transmission interconnection of the two respective properties?
We've had initial conversations with National Grid in regards to the potential transmission route. No feedback has been finalized there and won't be finalized for a little while. And then, sorry.
Go ahead.
And the crossing of the MBTA rail is actually owned by CSX. We have submitted our application for that crossing, but again, don't anticipate any issues there, given the existing transmission facilities crossing the same location.
Okay, thank you. Is there anything in writing? I realize that you're still in, it sounds like you're still in discussions with National Grid. Is there anything in writing from either of the landowners approving this plan, or something that we could hang our hat on that this is approved or okay?
No, not yet.
Okay. All right. Refer to the next is a little bit more on what Presiding Officer Sharkey was referring to, a kind of a comparison of the new and the old battery products. How do the lithium batteries compare to the originally proposed batteries, the SunGrow Power Titan 2.0 and closed batteries, in terms of charge capacity?
They have about the same charge capacity. I don't have the exact figures, but.
Okay, they're essentially the same, you're saying?
Correct.
Okay. And I think that this has been addressed, but safety, normal operations and emergency fire, are there any substantive differences in terms of these kind of parameters?
No.
Frequency of thermal runaways?
No.
Fire?
No.
Fire plume content?
No.
Toxicity?
No.
Design life?
No.
Maintenance requirements,
No,
cost.
no.
Okay. And the rationale for the different number, I believe there's a different number of battery units themselves. So what is the rationale for the difference in numbers?
Yeah, I believe we answered that previously, but due to manufacturing recommendations on spacing of inverters and of the battery modules, as well as the sound reduction kits, there was a reduced number of modules that would fit on the project site.
Okay, thank you. Let's talk a little bit about soil erosion and sediment control. Refer to the supplemental attachment B from November 5th, 2025, supplemental storm management memorandum at 7. And we understand that there is a new and improved stormwater management plan that was submitted last Friday. We will be discussing that some too. Really, this could apply as well. In fact, probably moreover applies to the more recent, which we've only had a little bit of time to look at. But we'd like to talk about construction and soil erosion. Describe soil erosion and sediment control BMPs intended for use during construction, i.e. what types of BMPs are used when and where?
I can respond to that particular question. This is Mark Bergeron. As shown on the project plans in attachment A, typical best management practices during construction to prevent erosion and sediment from entering any adjacent wetlands or water bodies would include a gravel pad construction entrance, also perimeter barriers such as either silk fencing, hay bales, or straw bales along limits of disturbance. If there's dewatering required, any potential pumping of groundwater would have to get run through a hay bale corral or some sort of filter bag to filter out sediment before it was allowed to infiltrate back into the ground. And also best management practices such as routine street sweeping and also an inspection program that would ensure that all of the types of best management practices that are prescribed for the site are in good working order on a regular basis and maintained by the contractor.
Okay, thank you, Mr. Bergeron. And would in any way these BMPs change from the December filing for the stormwater management plan to the February, I believe, 6th filing?
Well, with regards to stormwater, I don't believe so. I can let the civil engineer speak to that. But as far as with the erosion control and best management practices that I just described, they have not changed. Those are all still applicable to either design.
Right. Yeah, I'm specifically referring to the BMP, the sediment control and soil erosion BMPs right now.
Yes, Frank Holmes, Flanagan Engineering, so I can speak to that. And no, there's no change to the soil erosion and sediment control approach with the revised stormwater design.
Okay, thank you. Next, we turn to failure risk and during construction. If you'd refer to the company's response to EFSB S39, the statement made in that is that EPRI's root cause analysis makes clear that the most common causes of BESS failures are not cell or module defects, but rather errors in integration, assembly, construction, and controls. The question is, what strategies are proposed by the company to reduce failure risk due to construction?
We work with qualified third parties that build and design these sites for construction. We have a large construction safety division within our company and take safety incredibly seriously. There would be a construction management plan developed and submitted to the town prior to construction beginning that would address the specifics of that. But during our construction of projects previously, we've never experienced any sort of safety issues during construction.
I see. During ship construction and testing, there's of course the concept of the shakedown cruise. Can you describe how, once constructed, you test your facilities to ensure safety and appropriate operating parameters?
Yeah, there's a number of checklists that the project has to go through prior to commencing full commercial operation. This includes testing with the battery manufacturers, the inverters. We have internal checklists to make sure that everything is operating normally, as well as checklists with the independent system operator and the utilities to make sure that all of the batteries, inverters, and other equipment are operating as expected.
Thank you. And approximately how many facilities has your company put into operation?
I believe one is fully commercially operating, and another is expected to come online soon, but that could be, I'm not super close to those projects, but there's at least one in commercial operation with others in construction.
I see. The other one, and if you need to look this up, that's completely fine. But the other one that's about to go operational, is it going operational in 26, in 27, in 28?
It should be 26, if not early 27. It's very close, is my understanding.
Early 27. Okay, thank you. Next, please refer to the HCA at 15 to 16. This addresses project insurance itself. What would be the magnitude or dollar value of the property and casualty insurance for the project? Like what kind of insurance policy are you taking out for PNC?
I'm not close enough to that decision to get that answer to you, but I would be happy to provide that.
Okay. Okay, we may want to do a record request for project insurance. There's a few other questions that we would like to for you all to respond to as a record request. The second one is what would be the magnitude and dollar value of an insurance policy to cover town payments from the company? So you're negotiate a pilot agreement, and the town would reasonably wants to ensure that those payments are going to be made over the next 20 years or so. So is there insurance? I believe that you would reference that in your HCA.
I'll have to take that as a records request as well.
Okay, very good. And the last piece of that for the record request is how are these policy values determined? What is the rationale for these policy values?
Yeah, I'll take that as a record request as well.
Thank you very much.
So as record request EFSB-1, there are a series of questions regarding the property and casualty insurance for the project. The first being, what would be the magnitude of the property and casualty insurance for the project? The second being, would the magnitude of the insurance policy cover the town payments from the company? And last, how were these policy values determined?
Yes. Okay, the next we'd like to turn for a couple of questions to hazardous waste management, and specifically with regards to secondary containment. And specifically, what is the design containment volume for the secondary containment for the main power transformers relative to the volumes of transformer oils and other hazardous substances at the project facilities, at the project substation, and medium voltage transformers. In other words, for the bulk stored hazardous substances on site, what's the volume of those substances? And then what's the volume of the secondary containment?
My understanding of the main power transformer containment area is that it's 110% of whatever the hazardous material is, which in case would be oil for the
I'm sorry, I couldn't hear you. Whatever the hazardous material is, what?
whichever the hazardous material is, which in the case of the main power transformer would be oil.
Okay. And how is precipitation factored? I assume some of this is open air, or is all of this enclosed? I would assume that the secondary containment in certain cases is open to the environment, yes? Or is this all under a roof?
No, it is open to the air.
Okay. So in which case, how is precipitation factored into secondary containment volumes? That's often an engineering consideration.
Sure, I can let the civil engineers answer that, but again, it's 110%. So I think that 10% would provide for some of that, but.
Yes, excuse me. Yeah, my understanding of the secondary containment for these transformers is that it's typically achieved with a containment curb and a volume that is provided with a low permeability soil, so that if there is a release, it can be captured and removed. But it does allow for any precipitation to slowly drain through that soil.
Okay. And in terms of things like a 25-year storm event or anything, was that considered in the volumetric determination of the secondary containment? The size of storm, size of precipitation event.
I believe it would be, yes.
Okay.
As that design is finalized, it would be.
Okay, thank you. Okay, I have a quick EMF question, but I know that do we want to wait till Friday for that, or can I ask it now and you can decide if you want to answer it now or on Friday?
That's fine.
Okay. Refer to attachment D supplemental at 1. Exponent understands that instead of batteries from SunGrow's different manufacturer, this is what the statement is. Exponent understands that instead of batteries from SunGrow, a different manufacturer, Lithium, will be used in the project. The battery manufacturer does not affect MF analysis performed and discussed in the exponent report. And the question is, what is the basis of this conclusion? We have heard with your discussions with Presiding Officer Sharkey as well that there's no, and previous discussion, that there's no difference. But what is the basis of that conclusion?
Mr. Riley, I might say we should wait till Friday since it's down.
Okay. Okay. Very good. That
we will. It might be more general question.
Okay.
No problem.
I thought that was a general question, but okay. No problem at all. We'll just somehow mark that needs to be asked. Sure. And a quick question also, sorry to keep rounding different topics, but we just have a lot of different types of questions for you. Historical and archaeological resources, we heard your discussion, and we're happy to hear that that the Mass Historical Commission was an approval. But refer to the petition attachment E at 3. Describe how the project does or does not impact identified pre-contact archaeological sites. The reference had alluded to a pre-contact archaeological site. So we're wondering how does the project affect that referenced site?
The project
I said there's a little site there or something.
The pre-contact site. as
I'm
indicated-
sorry, who's speaking?
I'm sorry, this is Mark Bergeron.
Oh, thank you.
As noted on page 3 of 5, that pre-contact site, although located within the proposed project area, is not within the impact area of the connection. Yes, that's the transmission interconnection. So the project avoids that particular pre-contact site with its chosen interconnection pathway. And MHC did concur with their email response.
Oh, okay. So you're saying that it's in the general area of the project, but it's not impacted by the actual footprint of the project. Is that correct, Mr. Bergeron?
That is correct.
Okay. Well, thank you very much, everybody. I now turn it over to Presiding Officer Sharkey for a couple of questions.
Mr. Ryan, back to you. Can you tell me whether any of these changes, including project design changes due to the change in the battery type, changed the zoning exemption analysis that you presented in the initial petition at pages 37 and 38?
No.
Have there been any changes in the zoning ordinances in effect in the town since the filing of the petition?
Yes, I believe in May, the town adopted a new or an updated zoning ordinance that allowed for battery storage to be a special use within the district that the project is zoned for. However, due to other zoning regulations, we still require an exemption.
So as record request EFSB-2, could you provide a copy of the change in the zoning bylaws that you just referred to?
Yes.
Thank you. Mr. Strasberg.
Actually, Presiding Officer Sharkey, if I may just seek a clarification for a comment previously made before Mr. Strasberg starts. I believe it was in reference to the 2024 Act, and it was a question, I think, Presiding Officer Sharkey, you had posed in what the goals were of the 2024 Act, and I believe the respondent mentioned that we were looking for 500 megawatts by 2030 rather than I think it's 5,000 megawatts by 2030.
Correct. Apologies.
Okay, I just wanted to make sure in the record we have that. Thank you. Mr. Strasberg.
Thank you, Mr. Riley. Good morning, all. I'll now ask some questions about visual impacts. Turning first to the company's response for EFSB-V-1 parens 1. So these would be the line of sight renderings. First off, please confirm the time of year that these renderings depict.
I believe the renderings submitted depict a summer condition. However, we have requested and expect very shortly winter condition renderings that'll include off-leaf conditions.
Okay.
Do you know, Mr. Ryman, when those will be provided?
I've been told by our consultant by the end of the week.
Okay. Secondly, is the tree canopy, as shown in the aerial rendering on the first page of that document, representative of the actual tree canopy during leaf-on months in the summer as is shown, including and perhaps especially along Clinton Street, but more broadly between the project itself and the Emerald development?
I mean, it's not going to be 100% accurate. It takes data from Google Earth and scans that are available to our consultant. However, it should be representative of the existing conditions.
Okay. Do the renderings assume the existence of all of 125 Washington Street and 123 Clinton Street, parts of which are now concealed by the tree canopy in the aerial perspective?
I believe in the updated visual renderings that were submitted, 123 Clinton Street was added in to be more visible to better reflect the current conditions of that site.
Going back to that aerial, can you orient me, please, to the locations of any lightning towers that would exist there?
Yeah, so at the time of the renderings being completed, the substation design was still under development. That rendering is just a generic substation that was placed there as a stand-in for our project substation. There is not a lightning mast in that photo or in the visual rendering. However, we could provide one if requested, but a lightning mast will typically just be a single monopole about 2 feet in diameter, extending up.
I'm sorry, about how many feet in diameter?
About 2 feet, 2 to 3 feet, as it kind of tapers off. Essentially just a single monopole extending slightly above the rest of the electrical infrastructure.
Okay. So I guess aligning with the current update that you're doing in terms of winterizing the visual, I would make a record request to revise both the aerial view rendering and all of line of sight renderings to depict dead of winter, so January, February, leaf off conditions. So trees would be completely bare, deciduous trees, that is. And further, to revise the renderings to include as view sheds permit, the structures at 125 Washington Street, 35 Hillman Street, and 123 Clinton Street, any lightning masts, and any current landscape features along and in the vicinity of Portland Street that would not be removed by the project, including any structures, stored items, and material piles.
Does the company have any questions with regard to that record request?
We do not.
In that case, that would be record request EFSB 3.
Okay. I'll now pivot to EFSB-G-1, parens 1, at parts 1 and 2. Do these renderings also depict summer conditions like the previous?
Just 1 minute.
course.
Thanks. Could you repeat the question, please?
Sure. Do these renderings also depict summer conditions like the previous?
Yes.
Okay. Do these renderings accurately depict the landscape features along and in the vicinity of Portland Street, including any structures, stored items, and material piles?
Give me one more minute.
Sure.
Um, Due to the site's constant changing nature, as it is an active work site, it's hard to say exactly what it looks like today. But given the data that we had available to our consultant at the time of the renderings, it should be an accurate representation of the general area's use and visual look. However, the renderings were designed primarily to show the project's visual impacts, and not as much effort was put into the surrounding areas.
Mr. Ryan, could you tell us if some of the visual and materials that have been submitted subsequently in the most recent future, or which are anticipated to be provided in the near future, provide more detail with regard to the questions that Mr. Strasberg is asking?
They do not. Those were intended to show the visual impact from the Emerald Court neighborhood, as well as from the street. We do have aerial drone footage that we can submit of the existing site today that was taken by our landowner about a year ago, which gives a better visual, a more accurate visual of the surrounding area as it appears today, if you would like.
So that aligns with a record request if I could make, that I could make. And I would ask if you could revise all renderings to include, as view shed permits, any lightning towers, any current landscape features along and in the vicinity of Portland Street, structures, stored items, material piles that align with the aerial footage. And further, to revise all renderings to depict dead of winter, i.e. January, February, leaf off conditions.
We understand.
Okay.
So that would be record request EFSB 4.
Thank you. I'll now pivot to questions about site selection, specifically regarding candidate site 3. And I'd like to refer to the initial petition at pages 16 to 17, please. So regarding candidate site 3, the initial petition discusses two potential routes to the interconnection substation. One over or under the wetlands, considered unviable due to impact on the wetlands, and one within public roadways considered unviable due to cost. Please describe these two routes.
Yeah, so the first route from candidate site 3 would have consisted of crossing a substantial amount of wetlands, as well as the CSX railroad. The other one would have required undergrounding of much longer route under public roadways.
In terms of the crossing of the CSX railroad, is that the same type of crossing that's being proposed for the preferred project site?
It is, however, there is not existing crossings of the CSX rail quite that far down on the rail line. So the proposed crossing that we have today is already a higher impacted and I guess section of the rail line. And therefore we believe, and CSX has indicated, they would be more comfortable crossing at the proposed location due to already existing electrical crossings at that location.
Okay. Can you describe any other routes besides these two that there might be from candidate site 3 to the point of interconnection that may or may not be unviable?
No, all other routes would have had even greater impacts to wetlands or private property that would not have been available.
Okay. In terms of the wetland route, describe the areas required for the entry and exit pits, assuming underground transmission, and why these areas would necessarily prove detrimental to the wetlands.
This is Mark Bergeron. Could I ask, are you referring to the potential interconnection from candidate route 3, or are you
Yes.
asking specifically related to the proposed action?
I'm asking with regard to the transmission line from candidate site 3 that would go through the wetlands. And I believe the initial petition discusses disturbance that would be created from entry and exit. And I'd like to know a little bit more about the extent of that disturbance and whether it would necessarily impact wetlands or how it would necessarily impact wetlands.
Okay, I understand your question. Do you know if there is a discovery question that I could refer to that provides that?
I'm not sure.
I think so.
Actually, I believe we've identified which one it is. Thank you. The company's response to EFSB SS6 addresses this question. The direct distance between candidate site 3 and the interconnection substation would be about 2,000 linear feet. So with regards to a horizontal directional drill of this, which would be from that site across the extensive wetland system to the north and then into the interconnection system, generally this is a very long drill. And again, there's a general prohibition on horizontal directional drilling underneath an active rail corridor. And then the entry and exit pits would need to be approximately 75 by 100 feet in size. And given the space constraints specifically at the existing National Grid substation, which is surrounded by extensive wetland system. This entry-exit pit would have to be located within a vegetated wetland that would result in over 5,000 square feet of direct impact. Whereas the proposed project cited on candidate site 4, which is the project site that has been chosen as the preferred site, has less than 5,000 square feet of impact from its interconnection to wetlands.
I'm sorry, from its interconnection to what?
To wetland resources.
Thank you.
So I guess what I'm asking is, are those the only potential locations for the entry and exit pits? Or are there other locations that would not impact wetlands or would have a minimized impact on wetlands?
I understand your question. The entry and exit pits would have to be at the start and end of the drill. So they would have to be right at the National Grid substation, which is surrounded by vegetated wetlands. When we assessed this potential option, did not appear from the geometry of where the horizontal directional drill would be coming, that it would be possible to locate an entry-exit pit outside of mapped wetlands around the substation.
Okay, thank you. I'll now pivot to questions about expense, cost, vis-a-vis candidate site 3. If we could refer to the initial petition at pages 16 to 17, please. Please walk us through the reasons why utilization of candidate site 3 would be more expensive than utilization of the preferred site.
So I think primarily the distance and engineering complications that come with horizontal drilling, wetland impacts, as well as the general distance, would have made it substantially more expensive than the proposed route.
Thank you. I will now hand it back to Mr. Riley.
I think that we're going to the next section. Yeah, I think it goes to Donna.
Oh, sure.
Were you thinking, Nathaniel, we were moving to facility operations?
Yeah.
I thought so.
Okay. So given that that is something that's probably going to take us some time to address on the record, I think it might be a good time to take our lunch break and to pick up with this when we return. As we discussed earlier this morning, we talked about listening to some oral argument from Mr. Kaplan and from Mr. Senni when we come back from the lunch break with regard to the issues in the motion to compel that was filed by Mr. Senni and responded to by the company and further responded to.
I'll make it and let's keep it short.
So I expect we'll pick up with that and then after that resume with questions from the bench.
Okay.
So it's based on my laptop, 12:05. Let's come back at 1:15.
Thank you.
Thank you. Off the record.
Thank you.
Thank you. delay on it.
You want to turn?
Yeah.
Stop it. So I'd like to thank everybody for being so prompt, coming back on time. Let's go back on the record, Mr. Brock. So we are resuming with the hearing. However, we are going to take up the issue of some basically brief summary oral argument on the motion to compel filed by Mr. Senni, to which the company has responded. Mr. Senni, you have the chance to go first as the proponent of the motion. You're on mute, Mr. Senni.
Thank you. The motion to compel includes 6 areas where the attorney for the company and I could not agree on some disagreements about discovery requests. We did resolve many, but these 6 we just couldn't resolve, so we agreed that I should file this motion. Items 1 and 2 are satisfied. And actually, when I filed the motion, I predicted that these would go away. Attorney Kaplan and I agreed I would put them in just in case, but he reported that these renderings were in the works, and in fact, the renderings have been provided. There are a number of other renderings in the works, including a request I made for a line of sight drawing, and I know that is in the works as well. And today, through record requests, some other renderings were requested. But in terms of the 2 that I asked for assistance making sure we got, I can withdraw those requests for enforcement.
Thank you, Mr. Senni.
You're welcome. With regard to motion to compel number 3, which asks for the project, how many substations were evaluated to determine interconnection viability? The response by counsel was that the information requested is outside the scope of the proceeding. I don't agree with that. I think the question of looking at alternatives and alternative sites is very much related to the ultimate question in this petition, which is it reasonably necessary for the convenience or welfare of the public to put this facility in this location? And historically, it has been important to the Energy Facility Siting Board to review, and applicants have traditionally presented information about other alternatives. It appears to me that this has been a very limited review of alternatives, limited only to finding a site to connect to this particular substation. So I asked, well, how many substations did you take a look at? And did you look for sites around? And the answer was it's outside the scope of this proceeding, but I don't believe it is. From page 38 of the petition, the company's attorney wrote, when making a determination as to whether a petitioner's present or proposed use is reasonably necessary for the public convenience or welfare, the siting board examines the present or proposed use and any alternatives or alternative sites identified. That is citing from the EFSB decision in Cranberry Point, a best facility petition that the board ruled on in 2023. So I think every aspect of looking at alternatives is at play here and is relevant to the present proceeding. So I would like that question answered. I would like to know how many sites did they look at how many different substations? I want to be sure that this was an earnest effort to examine all possible sites. Next, there is 4, 5, and 6, which can be really joined together in an argument about whether we can ask the company for more detail about why a 1,200-foot transmission connection from the project site is fine, but a 4,000-foot transmission connection from candidate site 3 would be, quote, prohibitively expensive. In these 3 requests to compel the information, there's a real comparison here, and there's a real urgent need to know, not just have the company say, oh, that would be prohibitively expensive, but to show us why. It's a 2,800-foot difference in terms of wetland disturbance. At the project site, it is said by the company that they will disturb more than 5,000 square feet of wetlands, but there is no plan. There's no detail. We don't know where that area of 5,000 square feet is or what is really involved in that disturbance. At candidate site 3, there are 2,000. I'm sorry, I have that backward. At candidate, yes, at the project site, there's over 5,000. At candidate site, there is about 2,000 square feet of wetland disturbance. In terms of the transmission line itself, at the project site, the 1,200-foot transmission would include 1,025 feet below ground and 175 feet above ground. In terms of the connection from candidate site 3, we don't know, because there is no plan, whether this could all be done overhead or part would be done underground. There is no detail there. The project site is in a zone 2, which is a wellhead protection area, and candidate site 3 is not. And when a project is located in a zone 2, it opens many issues related to stormwater and protecting the public water supply at issue. This public water supply in question here at the project site is a 300,000 gallon per day DEP design flow approved well that serves the Tewksbury Hospital. It's an important water source, and we are now proposing to construct a project within a zone 2 when there may be a viable site that is not within that zone 2. In terms of residences, there are no residences within 1,000 feet of candidate site 3. We can find that in the answer to EFSB SS-8. Here, with the project site, there's one home within about 80 feet. There are 14 single-family homes within 1,000 feet. There's a 470-unit multifamily housing project, including an assisted living facility, that begins about 650 feet away, and a pretty good portion of that is within the 1,000 feet. My clients own the home that is 80 feet away. Their tenant, William Martell, went to the Board of Health and Select Board meeting on February 28th and asked for protection. He is concerned about his safety. These are real issues, and there's a real reason for us to take a close look at the project site and candidate site 3. And I think it is reasonable when one of the primary reasons given for rejecting candidate site 3 is that this 4,000-foot transmission connection would be prohibitively expensive without any breakdown or any explanation. I believe it is reasonable for the EFSB staff and all parties and the board itself to have this breakdown so that the analysis we're involved in can be very complete and very thorough. And the final one is a motion to compel number 6. I had asked how much is being paid for the land. I appreciate the sensitivity in such a question. I have mixed feelings about it. It's not something I wanted to ask, and I don't mean to pry into specifics of an option to purchase land. I am frustrated, though. This is a $125 million project. The company has just promised to pay the town of Tewksbury $2 million a year. There's a lot of money involved here, and I'm concerned that there is a lack of a reasonable connection between market value and what has been offered for this site. I honestly don't know if I am entitled to this information, or the public is, or the Energy Facility Siting Board is, but I raise it because I am concerned. Sorry, I can't stop that ringing. I am concerned that there is a lack of a relationship between market value and what's being offered to this seller. Thank you.
Thank you, Mr. Senni. Mr. Kaplan.
Thank you, Madam Presiding Officer. I would like to agree with Mr. Senni that we did try very hard. I enjoyed our conversations in trying to resolve many of these issues. We just were not able to do that. Essentially, the Pomashian is requesting information about alternative sites asked in several different ways. So let's start with the precedent as I read it. Mr. Senni quoted the EFSB or DPU decision on Cranberry Point, I believe, where the siting board or department precedent was clear. With respect to a particular site chosen by a petitioner, General Laws, Chapter 48, Section 3, does not require the petitioner to demonstrate that its preferred site is the best possible alternative, nor does the statute require that the department or the EFSB consider to reject every possible alternative site presented. So with that precedent in mind, the Pomashian focused on the transmission line. In terms of the transmission line, they wanted to know what is considered a line that is close to a substation and what makes one line more expensive than another. We responded that a 1,200-foot line in our proposed site is closer than a 4,000-foot line. That seemed obvious to me, but the Pomashian wants to know the definition of the word close and its impact on the cost by asking why a 4,000-foot line was determined by the company to be prohibitively expensive. As we've explained numerous times in responses to discovery requests, and even on the record this morning, costs are not just about the price of the transmission line. Costs include the terrain you need to deal with, the impacts on wetlands, the number of parcels you need to permit, the road crossings that you have to take, the number of trees you need to remove, and so on. Pomashian's role as an intervener, and with all due respect, I believe the role of the EFSB in this proceeding is to determine whether this project is in the public interest and not whether the EFSB or the Pomashian prefers another site with a longer transmission line or another site with a different interconnection point to a different substation. That is simply not what is being evaluated in this proceeding. We are proposing to interconnect one project to one substation. The Pomashian also asked for the company's cost to purchase property. Mr. Senni is correct that the sale price will become public eventually. But like every other real estate deal, he and his clients are going to need to wait until the information becomes publicly available. The town entered into an HCA knowing the property value and the proposed cost. The town and the company are finalizing a tax agreement that the town will determine is in the public interest, or they're not going to enter into that agreement. Whether the Pomashian think they could have negotiated a different deal or a better deal is simply not relevant to this proceeding. The company has presented its preferred site, the site of alternatives it considered, the reasons for the rejection of those sites. The Pomashian requests are simply not within the scope of this proceeding. Thank you.
Thank you, gentlemen. At this time, we're going to continue to review the issues related to the scope of the alternatives analysis and what information is required related to that as part of this zoning exemption proceeding. I do agree with the company, but I agree even more frequently with our general counsel who wants to say something.
Thank you. I appreciate both sets of arguments, and you both approach this question a little bit differently. And I appreciate having read the filings and having just a little bit more information directly from the both of you. Thank you. So I would ask a question, and maybe I'll start with the company. Given the fact that alternatives analysis is mentioned in our standard review, I would be interested in hearing from the company the scope, what the company's position is on the scope of that analysis, and what factors should the board consider in order to make a finding on that part of our standard of review, the alternatives considered part of the standard review. I'd be interested to hear the company's position on that.
Thank you, Ms. Evans. So the company has followed the precedent in what's been done for years and has set out parameters that they looked at in choosing alternatives. So they needed things, and I don't have the exact list in front of me, but they needed to review things such as, maybe I do have the list in front of me. Thank you. Where a substation was, whether or not there was availability to interconnect to that substation, whether or not the utility would allow an interconnection to that substation. The amount of land that's available for a 125 megawatt battery energy storage system, you need a specific amount of land. So you need to find space for the project. Are you looking at industrial zone versus residential or agricultural? Where is the best place to site this? And how is it going to be with minimal impact to sensitive receptors such as residents, wetlands, other things? So in general, the company evaluated several sites based on those and said, okay, this site has enough land. Site B has enough land. Site C, not enough land. So we're crossing out site C. Site A is, 1,200 feet to a transmission line or interconnection point. The other is 4,000 feet. What is 4,000 feet going to involve? And is that, I understand we use the word prohibitively expensive and everybody is stuck on that, but in reality, it really means a lot of things, not just the price. It means the cost to the local community, the number of trees, things like that. So we set out the parameters of what we were looking for in terms of site selection. We provided other sites that are in the area that we also looked at, and we explained why we rejected those sites.
And does the company feel that this level of detail is adequate for the purposes of the siting board making its findings regarding alternatives considered?
So it seems like for 50 years or so, that's been the case. So I would answer that to be yes.
And Mr. Senni, as far as your clients are concerned, you have a different point of view on the scope of the alternatives analysis, is that correct?
I do.
And what additional factors do you propose that the siting board look at in addition or above what Attorney Kaplan just gave us?
I'm not sure that my list would be longer. I think he's identified key issues, but he hasn't really addressed them on each of the 4 sites. He says cost is important, but it's not the only issue. I agree, it's not the only issue, but he's giving us no information on cost. And yet the reason Site 3 was rejected was because it would be prohibitively expensive. So let's have the count of the trees to be removed. Let's have a comparison of the wetlands impact. Let's have a design plan of the distance we're going to take this transmission line and what will be the real impacts on the ground. Let's look at all of these costs. But to have just a simple bare paragraph in the petition that doesn't do any of this analysis, where there are no plans to compare the site planning for those 2 transmission lines, your board can't evaluate it. So I agree on what the areas are that should be looked at, but we have been given very little. In fact, in my opinion, this is just checking a box with candidate sites 1, 2, and 3, which were not selected. First of all, we don't even know if there are other substations or other areas near a circuit between substations that would have much more breathing room for a BESS facility. That should be looked at too, the larger picture. You know, in Cranberry Point, the applicant actually looked not only at sites near the proposed facility, but a site in Falmouth and a site in another town. They were not limited to one substation. They looked around and they provided more information. This is as bare bones as it gets. And in my opinion, it is simply checking a box. Yes, we looked at some other sites. Sites 1 and 2, I'm going to get into this when it's my time to cross-examine the company's experts, were never viable. And I'm going to show that. I'm going to elicit testimony on cross-examination that those 2 were never viable. This is simply checking a box. And I'm opposed to that. I think the board is entitled to get specific information to make sure that what is statutorily required, which is to look at alternative sites, is done earnestly and realistically and thoughtfully and carefully and thoroughly. And it hasn't happened here.
Thank you.
Play that out. Oh, I'm sorry.
Mr. Kaplan, would you like to respond?
I would. So if you play that out and every company comes in and provides the cost of all their alternatives. So let me back up just a little bit. This is a private company. This company is covering the cost of this project. It's the risk, any risk is being taken by the company. It really is not whether or not somebody else can find a less expensive route or a cheaper way of doing this, or a more expensive way of doing this and think that that's a better thing to do. If you play this out and you provide all the information that's requested, what does that do to 48 Section 3 in terms of a comprehensive or an individual zoning exemption? Is it that the EFSB or interveners would now be arguing that actually Bill Rick is a better place for this project because I could find a cheaper line or a more expensive way to do this? Is that where we're headed? And it just doesn't seem like that's where the precedent is. I understand what Mr. Senni is saying, but we're filed under a specific statute. And under that statute, there's 50 years of precedent. And we're following the precedent that was set.
Thank you, Mr. Kaplan and Mr. Senni. I have no further questions at this time.
So I believe that siting board staff is going to consider what was said in this argument. It's been very helpful to provide further information. Not that you guys didn't do a wonderful job on the motions, but it does provide us with better context to make a determination with regard to the motion to compel. And we are going to further defer ruling on that while we consider what was said this afternoon. So thank you.
Thank you.
So I believe we are resuming with questions from the staff at this point.
Are you going to? I think at this time I'm going to pass it to Mr. Riley.
So Nathaniel, if you do not have follow-up questions on what you were pursuing before we broke for lunch, then there is a brief number of questions I'm going to ask with regard to the company's project outreach.
Please.
So, Mr. Ryan, if I can point my questions to you and someone can chime in on the panel if needed with regard to the questions. You provided responses to EFSB G6 and EFSB G7 with regard to community outreach activities that the company has pursued with regard to the project. So I would like you to provide me with additional information that focuses more on community outreach unrelated to the company's discussions with the town, and to focus on outreach to abutters and other members of the community within Tewksbury regarding, in particular, the project update that was filed by the company in December, and what activities have occurred since the filing of that update.
Are you referring to the change in battery manufacturer?
That's right. That's what I refer to as the December 4th supplemental filing.
Sure. In regards to the supplemental filing, outreach to adjacent landowners and community members has been relatively minimal, given that the change in battery manufacturer we didn't view as a substantial change to the project. Visual impacts were not going to change. Sound impacts were not going to change. From adjacent properties, the project remained almost entirely the same, and felt that given the hearings ongoing, it was best to wait for the evidentiary hearings. In regards to prior to the change, we had numerous meetings with both community members, the town, adjacent landowners, to discuss the project. That was all reflected in G6 as well as our petition.
I'm sorry, that was all reflected in what?
His answer to G6, I believe, is what he said.
We also, yes, G6. We did also meet in front of the select board after announcing the battery change, I believe, which was a public hearing in front of the Board of Health. Apologies, not the Select Board, the Board of Health.
So is it accurate to say that the outreach activities, probably since the December 4th supplemental filing, were more directed towards the town and other boards within the town?
Yes.
Okay. Okay, thank you. So sorry, thank you, Mr. Riley. If you wish to proceed, then please do so.
Thank you, Presiding Officer Sharkey. Good afternoon, everybody. So the first question I have, this gets into operations. Who would own the project once constructed specifically during the operational period?
Yeah, the plan is for East Point Energy to own and operate the project.
Okay, so East Point will also operate it.
Correct.
Okay, okay. Refer to the company response at EFSB G8. And it stated, all maintenance and operation will be conducted by a qualified third-party contractor. This work will be overseen by East Point Energy's asset management and health, safety, and environmental teams. The questions are, who would be the third-party contractor?
We have not finalized the selection on that. It won't be until choosing a vendor for construction and operations, which typically happens much closer to actually commencing construction.
Okay. Okay. So, for your other facility, do you have that's currently operating? Do you have a third-party contractor right now that satisfies these functions?
We do, and there's also similar projects in Massachusetts that are operating or are close to operating, and so we don't anticipate having an issue finding qualified vendors to complete this work in Massachusetts.
Okay. Okay. Refer to the company response at EFSB N2. It stated the project will also utilize local labor. Questions are, describe the number and types of local laborers professionals to be employed during construction and also facility operations. So what kind of magnitude are we talking here?
Sure. During construction, we anticipate, I believe, between 40 and 60 staff on site, which includes electricians, civil, site grading, any sort of plumbing for water that's necessary as part of the project. The sound walls will require laborers, kind of typical construction, things like that. And then that'll all be as much union as possible. And then during operations, will be, electricians for maintenance of the project on site, as well as landscaping and kind of other civil, whether it's stormwater maintenance and things like that.
This is generally an unmanned site, though, isn't it?
Correct. Yes. During operations, we anticipate typically, we say about one car per week visiting the site for routine check-ins, maintenance, as well as landscaping and things like that. So during operations, we anticipate 3 to 4 jobs created, if you will. But then, like I said, during construction, it'll be between 40 and 60.
Okay. We'll probably follow up in a little while with the a description of the ROC and the central. There's those things, we'll hold off on that for right now. As far as maintenance, access to the batteries, refer to the company response at EFSB S15. How is the interior of a lithium an infinity lithium BESS unit access for maintenance purposes? How do you actually get into that? I realize you can't walk into this thing, but how do you work on them?
Sure. There's essentially cabinet doors on the exterior that open outwards for maintenance and construction purposes. So there's no interior space to walk inside of.
Okay. Okay. So you open the cabinets and pull out the modules and put new modules in, or?
Correct.
Okay. Is there anything else that you would do for maintenance, besides module replacement? I mean, what other kind of maintenance would you do for a unit like this?
Sure. I mean, there's other ancillary equipment on each BESS unit, whether it's air conditioning and kind of support equipment for the batteries. And so, if there's an air conditioning unit, that might require maintenance like any air conditioning unit would, and kind of similar maintenance around the support equipment of each battery.
Okay. Regarding gas emissions from the units, refer to the company response at DSS 19. Do the lithium BESS units give off measurable amounts of gases during normal operations?
Sean Morris, ESRG. No, during normal operation, they're not. Oh, yes.
Okay, so none less than below detection limit, or I mean, what is it really none?
Not with, in terms of specific gases that would be given off. They don't emit any gases that would reach detection limits or reach any safety thresholds.
Okay, thank you. Refer to the company's response at EFSB S55. It is stated, industry standard practices is that 60% state of health is the end of life for the batteries. Based on expected project operation, 60% state of health may not be reached during the 25-year project life. Question is, how is a battery state of health monitored?
That would be monitored through both the remote operations control center.
I'm sorry, that would be
through
monitored.
the remote operations control center, as well as our operations and asset management team. They have a battery management system, or BMS, that analyzes the batteries for degradation and state of health, and are able to tell kind of what the state of health would be at any given time.
Is it a periodic thing, or is it a constant monitoring? Such as, is there a dashboard at your ROC that says the SOH is 88% or something like that? Is that, how does that work?
Yeah, so based on the operation of the battery, so depending on how the battery is being discharged and charged, it's kind of estimated through an algorithm that will kind of give you a readout based on how the battery has been used and then the conditions that it has been used, to give you a value of the state of charge or state of health, apologies, of the actual battery cells.
So is it the company's contention that these modules never have to be replaced in the 25 years, or normally will not have to be replaced in the 25 years of operation?
Yeah, again, like I said in the response to S55, it's not anticipated that the batteries on site would drop below that 60% state of charge or state of health threshold. There might be batteries that are brought in to augment the reduction in energy at the site, but batteries are not anticipated to drop below kind of their operating state of health during the life of the project.
Will all the modules be new when you start them, or do you, I don't know, borrow them from other places and you start at 88% or something like that.
No, all batteries used at this facility, whether it's at, the start of the project or augmenting throughout the life, will be brand new batteries.
Tell me more about augmenting throughout the life. Under what conditions would such said augmentation be needed?
Sure.
Why would you do it?
Yeah, so during the life of the project, as batteries lose, the state of health, the battery might be at 80% of what it was when first installed. And in order to maintain the project's energy requirements with the utility or the independent system operator, fresh batteries or brand new batteries will be brought in to kind of empty containers at the project site to maintain the energy of the site.
I see. So at year, for example, 20, I mean, so we're getting towards the end of at least the design life, and realize that you might want to reasonably keep this going as long as you can. But let's say we're at year 20. Are we talking, 50% more batteries? You've kind of found a home for 50% more modules, or, is it a few more, or is it a lot more and I'm asking this because it matters in terms of the amount of electrolytic, fluid and stuff that would actually ultimately end up on site.
Sure. Yeah. So I think one of the clarifications here is the site that we are showing in the application, the 134 containers, is the end of life of the project. So every single one of those will be filled with batteries. At the time of kind of initial operation, when it first is turned on, not every single one of those containers might have batteries in it, but they will be ready to receive batteries as fresh batteries are needed to be brought in to maintain the state of health. So, if the project is dropping to kind of that 60% state of health at the end of the life of the project, it could be, 20 containers of additional batteries, but again, that's never exceeding that 34 containers that we have in the site plan.
I see. So this is fascinating. Thank you very much for this. So at the beginning, is it like half full of modules? Is it like about 3/4 full? Is it a quarter full? Like what about how full is it?
Yeah, it's more likely to be 75, 80%, but we don't have any sort of augmentation schedules or maintenance schedules built out yet for this facility.
Okay, thank you. Regarding backup power, refer to the company's response at EFSB S22. Second there. What is the anticipated duration of the backup battery power supply? Which is kind of a funny question since this is a battery facility, but we'd like to understand more about your backup power.
Yeah, so in terms of backup power, the auxiliary cooling systems and other battery management systems will be supplied through a separate independent circuit than what the batteries are charging off of. So even if the batteries lose connection to the grid in terms of charging and discharging, the auxiliary systems will still have power as long as the rest of the grid still has power. In the event that the power were to be lost, both to the auxiliary systems and to the batteries themselves, there are UPS or uninterrupted power supplies in each battery system to provide a certain amount of time of backup power. That's typically something that is negotiated as part of the procurement of the batteries on the timing. So I don't have exact numbers for you right now, but there would be a battery backup for the auxiliary systems in the event of a loss of power to the site.
Okay. So, during an actual power outage due to a transmission system loss that lasts several hours, describe how the following components would behave. the proposed project facility itself. So we're out of power for 12 hours. What happens to the facility? And I realize what you just said, so maybe how does that work?
Yeah, so in the event of an extended outage, a qualified professional or long-term service provider would be dispatched to the site to monitor it in person. That's kind of, if worst case scenario, it were to lose kind of ability to transmit, or it's the BMS systems are not able to kind of relay their information, but Sean might be able to talk more about that as well.
In NFPA 855, which is one of the guiding standards, it identifies specifically what components are critical safety systems. So in regards to the fire and life safety components, and NFPA places additional power supply criteria on it, similar to you would see with fire alarm systems, et cetera. And this project would comply with all those.
Okay. And I understood. I guess the question, let's get very specific. How long does the facility have before the BMS goes down and is no longer functioning? What would have to happen for the BMS to lose power and all of a sudden there is no more BMS system that's operating until the power comes back on again?
Yeah, I don't have any sort of specific time or details on that at this time.
Okay. I think it would be good to have a record request to understand what happens to a facility if the power's knocked out for 1 day or 2 days. We can have blackouts that are extended.
I'm just trying to think if there's stations.
We can make it easy. We can just say 2 days. What happens with a 2-day blackout? Yep.
Thank you. We understand the question.
I'm sorry, does that have a record request number?
Donna?
You're out of mute.
I think it's 5, isn't it?
Yes, sorry, didn't realize I was on mute. Yes, it's record request EFSB 5.
Okay, great. Moving on to Mr. Ryan, is it Ryan or is it Rin? I want to make sure we're pronouncing your name correctly.
It is Rin.
It is Rin. Okay.
Thank you.
I'm kind of a stickler for that, so thank you for humoring me. Regarding the temperature and safe operating range, Mr. Rin, you had alluded to this a little earlier. Refer to the company's response at EFSB S62. And it states, if such temperature conditions were to occur again, the expected impact would be...
I'm sorry, I couldn't understand you.
I'm sorry, Alan. I'm sorry. If such temperature conditions were to occur again, the expected impact would be operational rather than a public or a health or public safety hazard, with the system transitioning to a safe state until conditions return within the operating envelope. So the question is, what is a safe state and how would the system transition to it? What is this safe state?
In regards to that response from S62, those temperature parameters provided by the company refer to the guaranteed level of operation for the battery system itself. The safe state, I believe, in that response refers to back within the operating range that would provide their guaranteed performance, which, while including safety items, also includes charging, discharging, functionality that could be decreased with temperatures that fall outside of that range for periods.
Okay, great. Thank you. Is that the range that was quoted, the -4 degrees Fahrenheit to 131 degrees Fahrenheit? Is that what we're referring to right now?
That's the published documentation from the manufacturer to guarantee their operations.
What happens if we just had a real cold snap here? What happens if we get 10 below zero for a day? We have a polar vortex. They seem to be happening more frequently in the last 10 years. What happens if it's less than 4 degrees Fahrenheit for an extended period of time?
Much like my car took an extra second to start this morning, batteries are sometimes impaired by temperature, ambient temperature. Right. And while their performance can slightly decline, it doesn't represent a safety hazard.
Okay. You had mentioned, Mr. Rinn had mentioned some kind of an air conditioner. I don't know if there's an HVAC system in these or what exactly, but is there a heater? I mean, would a heater click on if it was real cold for a day or two? Or is it more just an air conditioner cooling unit?
So there's two essential cooling functions. One is the standard thermal regulation of the system to maintain a very tight operating range, and that's intrinsic to the system. The secondary is to reduce any combustible gas that could be given off in a failure state. That's a CCR system, which is a separate life safety system that would only be enacted should a gas detector detect hydrogen gas in excess of 10% of the LEL in the system, which would only happen during a failure event.
Right. Okay, so I guess it sounds like there are cooling units, but there isn't a heating unit. Is that a correct statement?
Yes.
Okay. And going back for a second, I guess I missed a question. Going out to a kind of a power outage, general regional power outage situation, how would the battery units contribute power during a power outage from transmission system issues?
Sure. So the batteries are connected into the 115 kilovolt substation at the National Grid, where our point of interconnection is. If there is a transmission level power outage or downed power line or something coming into that substation, the battery could provide kind of a local power supply at that local substation. The 115 kilovolt power supply from that substation is what goes out to the distribution system in the local area. Now, if there's a power outage due to a distribution line coming out of that substation that's down, our facility wouldn't kind of provide anything there. But on the transmission level, it is kind of a local source of power in that area connecting to the substation.
Okay. And this is something I just don't know. How low can batteries get while they're still gainfully adding to the local distribution system? I mean, can it get to 10%, 5%, 1%? In terms of draining their charge.
Yeah, I don't have the exact numbers on that. There is kind of a minimum state of charge that you want to bring. Right. You don't want to bring batteries below, as that can damage them or degrade them and damage their state of health. I do know that it's not zero. You don't want a battery to go to a complete zero, but I believe it's probably about 5 or 10%, but I don't have the exact numbers.
And there's the BMS system or something monitors and says, okay, shut off. We can't do anymore.
Yes.
Okay. All right. I think now we are transitioning to noise. It sounds like I have some and then you have some. Presiding Officer Sharkey, do we want to take a break or do we want to continue on? Either is fine with me.
No, it might be a good time to take our mid-afternoon break. Mr. Brock, do you have a preference?
Whatever you would like, it's fine with me.
Would 15 minutes work for you?
Sure, thank you.
Okay. So it's almost 2:10. Let's come back at 2:25.
Good.
Thank you.
Thank
Off
you.
the record. Does anyone have anything we need to address before we go back on the record?
Yeah, we seem to be missing a fairly
company.
large contingent here.
Yes.
We're here, we're just waiting for Andrew, he's just walking into the room.
Okay, thank you. Okay, let's go back on the record. Mr. Riley?
Thank you. Thank you, Presiding Officer Sharkey. In terms of post-construction noise monitoring, refer to the initial petition at 28. Would the company conduct post-construction noise monitoring to ensure compliance with the Mass DEP noise policy?
Yes.
If so, what would be the compliance monitoring plan? And if that needs to be sent as a record request, or if you could just describe it, you know, in 25,000 foot terms.
Sure, this is Ryan Callahan. So the post-construction monitoring, the first step for that would involve developing a sound monitoring protocol. And that document would then spell out how the testing would be done. And that is usually a process that would take place with cooperation from the town.
Would you use some of the same monitoring locations you did for the pre-construction monitoring when you did the modeling? Or that would just be under consideration?
Yes, that would be part of the protocol development, is identifying where those measurement locations would take place.
Okay, great. But the bottom line is, at this point, you don't have the plan. That would just be something that, as you're going to construction, you would develop that in concert with the town. Is that a correct statement?
Correct.
Okay. Okay, great. Thank you. Regarding noise attenuation, refer to attachment C, supplemental noise assessment at 20 to 23, and also page 33. How were the sound walls?
Excuse me, Mr. Riley, so sorry. Can you just give us a couple minutes to get there?
Sure, okay. Yeah. Take your time.
Thank you.
There's a lot of paper.
Exactly.
You all have been prolific.
Yep, I'm there.
Okay, great. How were the sound walls, low noise equipment, and silencing equipment modeled as noise mitigating equipment in the noise assessment study? In other words, how did you take these into account in coming up with in the modeling and coming up with your results?
Sure. So it's an iterative process.
I'm sorry, who's speaking?
It's Ryan Callahan.
Oh, thank you.
So the sound modeling is an iterative process. Essentially, when you have a site that you are evaluating, you plug in all of the sound sources and look at those modeling results, and then determine if mitigation is needed. If mitigation is needed, you start to look at the most effective ways at reducing those sound levels, which can be done at the source level in the form of sound mitigation kits, or it can be a physical barrier such as a sound wall. And essentially through a series of iterative acoustic modeling results that get refined, that's how the mitigation is determined. The appropriate level of mitigation is determined.
Okay. It wasn't clear how, I mean, the mitigation, just take, for example, I mean, the low noise equipment and the silencers understood, but the walls themselves, the sound walls, it wasn't clear to us how the height, the length, the thickness, and the composition was determined. I mean, and I assume that since this is an iterative process, you kind of played around with that. But how did you get the actual dimensions and the composition? How did you derive that? We don't need to know in gory detail, but generally, how does that come about?
So for this site, every component that is going on the site that's a significant sound source is going to have the manufacturer's silencing kit or low noise version of that unit. So once you have done that, you start looking at what benefit a sound wall can have. And you put a sound wall, the geometry of the sound wall gets entered into the acoustic model. And then, just as you described, we raise the height of that wall higher and higher until we achieve the desired level of mitigation to comply with the regulations. With respect to the material of the wall, the modeling actually assumed that the wall is a perfect barrier. And what I mean by that is that no appreciable sound will pass through the barrier. And in practice, that means that it has to be built to a robust enough spec so that that is true. It can't be a thin material. It has to be dense enough so that the sound that is propagating through it is negligible as compared to the sound that propagates over or around it.
I see. Yeah, because certainly it's not perfect, right? I mean, you don't sit on the other side of this wall and there's no sound. In fact, it sounded like from your results that, you do the mitigation to the point, well, this is a question. Do you do mitigation to the point of compliance with Mass DEP noise policy, i.e. 10 decibel A-weighted decibels above background? Is that sort of your standard for determining the degree of mitigation?
Yes, that's one of the limits that we evaluated for this project. Another factor is, could we make the wall, say, 1 foot taller and see an appreciable result? Because of course, if the answer is yes, then that would be a recommendation that you're going to add 1 more foot, and this will be even quieter than what we're proposing. But that's not the case. Once we get to the wall heights that we are proposing here, adding additional wall height would have an imperceptible change to the surrounding areas, unless you're talking about doubling the wall height or something really extreme.
Did the company take all of your recommendations for mitigation and
Yes.
adopt them?
Yes.
Yes. Okay. One moment, please. Based on your responses, I want to make sure that we're asking this correctly. So the supplemental attachment C at 33 and EFSB NO2, I'm trying to remember, are there pre-mitigation sound levels in that? In other words, mitigation sound levels at the monitoring points that you selected for your study, south and east of the facility, are there anticipated sound levels at the property lines without mitigation? Or is it, I seem to recall it's only It's only the sound levels at those property lines, at those monitoring points with mitigation. Is there the pre-mitigation sound levels as well, or only post-mitigation?
The sound report only shows the mitigated results, which is what's being proposed to be built.
Okay. Refer to the company response at EFSB-NO-6. States, the noise barrier will be constructed of a material with sufficient density to achieve a minimum sound transmission class rating of 30. And the absorption coefficient for the interface of the east and south barriers will be at least 0.84. Question is, how were these ratings derived? Actually, could you describe these? Could you give a short lecture on these ratings for those of us that are not sound engineers? I think my guess is there's only one in this entire group that's a sound engineer. So what does a rating of 30 mean, and a 0.84 absorption coefficient mean in generalist terms?
Sure. So I'll start with sound transmission class, or STC. That's essentially a rating that describes how good a material is at blocking the transmission of sound through it. So if I held up a piece of paper towel and I spoke in front of it, that's not going to do a very good job of stopping sound, and that would have a very, very low STC value of tenths of a decibel. If I have a dense material, such as a wall made of concrete or something, that could have an STC in the 40s or 50s, something very high. So it's a rating that essentially describes how good it performs at stopping sound.
If I may, for a moment, is it the factor decrease? So an STC of 30 would be about a 97% decrease in sound. Is that what it is?
It's more that you'd expect approximately 30 decibels of reduction to occur.
30 decibels.
If it was in a perfect laboratory environment, and,
yes,
and there was no sound capable of propagating around it, it was simply passing directly through it.
Okay, so it refers to the decibel, the approximated decibel reduction across the membrane. Is that
yes?
Right?
Yes.
Okay. Okay. So what is this absorption coefficient of 0.84? Can you help us with that?
Sure. So that is the measure of how good the material is at absorbing sound. Anytime sound encounters an object, some of that sound is going to reflect off of it. If you have a material that's acoustically hard, like a sheer concrete wall or a piece of ceramic tile, a very hard material, that would have absorption coefficient of 0 or something very, very low. Whereas the material that we're proposing for the sound wall is going to be acoustically absorptive, so that when sound interacts with that wall, the majority of that sound is absorbed. It doesn't allow for significant reflection of sound.
Okay. And quantitatively, does that mean that approximately 84% of the sound is absorbed? Is that what the 0.84 means?
It's a laboratory measurement again, so it's just a value that is describing, yes, the percentage that is either absorbed or reflected.
Okay. So the interior of a concert hall would have the walls would be made out of a high absorption coefficient. Would you agree with that? So it doesn't bounce, the sound doesn't bounce. Is that correct?
Well, a concert hall might not be the best example because they actually use a combination of reflective and absorptive materials
Okay.
to make it sound good to your ear. But the hard and soft material is a good comparison. So a very hard sheer material would be very reflective. Something softer like mineral wool, fiberglass, that would have an absorption of probably 1 because it's completely absorptive.
Okay, all right, thank you. Thank you very much. That's actually very helpful for us to understand your report better. I defer to Nathaniel.
Thank you, Mr. Riley. Please refer to the supplement to intervener witness Corey Nickchin's pre-file testimony at page 9, and that's exhibit number SDNC Parens S1.
I'm
Please let
sorry,
me know when-
that's exhibit number what, did you say?
Sure. Exhibit number SD-NC Parens S1. Please let me know when you're ready.
That the report dated January 19th.
Let me confirm. So let's see, that is the report. Yes, January 19th, that's correct.
Yes, I'm there.
Okay, thank you. So I'll read the quote. Because NCE and epsilon have similar methodologies for calculating the ambient background levels, NCE attributes the difference to the ambient background operating differently. Remember, epsilon collected the data in early March 2025, and NCE collected the data at the end of August 2025. NCE is not offering any speculation as to why there is a difference, only that there is a difference, and that NCE's values are lower and represent a more conservative value. In light of that statement, I'll first ask, how much could ambient background noise levels vary at the project site?
Well, in our report, we provide graphical representation of our measured sound levels that show exactly what the ambient does over our 8-day monitoring period. So I could refer to that to kind of visually express how they could vary. That is attachment C of the supplemental, our report.
Before you go there, I guess the point that I'm most interested in is that there's a variation in ambient between what epsilon has found and what NCE has found. And I'm wondering, among that variation, what the total scope would be. Can you provide a rough idea of what that might be?
So ambient sound levels are affected by seasons. When we collected our ambient sound level data, we collected it during the winter months of late February into early March. This report that you're referring to, they collected their data during, I believe, the summer timeframe. And that is definitely a part of the variability between the sound levels that we're seeing here. But there are additional corrections applied to their ambient sound levels that are not described in this report that also factor into the differences.
In terms of other factors besides seasons, could you name other factors?
Yes, their sound levels had a correction applied to them to account for the fact that they were measured during the warm weather summer months. During summer warm weather periods, you often have contributions from insects and frogs, other natural high frequency sounds. And those were removed from their data set prior to being portrayed in their report.
Okay, thank you.
Can I follow up on that for 1 second?
Yes, sir.
Why would background biological noises be removed from a sound assessment?
So it is typically done if you only measure during warm weather months and you're trying to approximate the colder weather months when those wouldn't be present. We didn't have to do that because we measured our sound levels during the cold weather months.
Thank you.
So moving on to the next question, it's the same document. Corey Nixon's supplement to Corey Nixon's pre-file testimony at page 10. And there I'll just read off a quote. Again, because the industrial areas are arguably deemed to not have sensitive receptors, there would not be an excess of the limits of I1 and I2 by epsilon. However, if they are considered to be sensitive receptor locations, the predicted levels would be in excess of 9.5 dBA, 19.5 dBA over ambient. And this would be observed in the middle of the afternoon when people are present doing work. So with respect to that quote, I'll ask, elaborate on why the company did not consider the office buildings in the industrial area to be sensitive receptor locations.
Sure. So it's not correct that we did not assume them to be sensitive receptor locations. Those locations are protected by the Tewksbury bylaw for noise. So the town of Tewksbury has its own sound level limits that apply to all land uses. And those values are in our report, and our receptors right at the property line of our project are compared to those values, and we do comply with those values. So any locations further away from those areas will comply with the town's limits.
Okay. Can you just provide a general description of what you consider to be sensitive receptors?
With respect to the Mass DEP noise limit, we would apply that at inhabited residential locations, the areas where people reside or sleep. With respect to the Tewksbury town limits, those are all properties, so it applies to every parcel regardless of its use. There's different limits depending on the use, but it encompasses all types of parcels from industrial, commercial, utility, uninhabited. It does not have any parcels that are left out.
Okay. Moving on to the next question. Same document, page 10. And the topic here is pure tones. And I'll read the quote. Because the step-up, transformer, and inverter are estimated, there is concern that a tone could be an issue once the actual piece of equipment is manufactured and arrives at the site. NCE cannot say for certain that there will not be a tonality issue when comparing it to the Mass DEP noise regulation. In light of that, I'll ask, please provide an overview of what pure tones are, what could cause them after project completion, and ways of mitigating or eliminating them if they are detected after project completion.
Sure. So the Mass DEP defines a pure tone as an octave band having 3 dB or more higher than the 2 adjacent bands. So if you're looking at sound levels graphically from low frequency to high frequency, and you have each of the octave bands plotted, if one of them is sticking above the 2 adjacent bands by 3 or more, that is defined as a pure tone by the Mass DEP. In practice, that can mean something like a bad bearing on a fan, or something that squeals, makes a tonal sound, a smoke alarm, backup beeper. Those are tonal sources that are more readily audible because of their tonality. Our analysis evaluated for the presence of a pure tone by predicting the worst case sound levels from the project and adding them to the existing ambient sound levels, and then seeing if any pure tone would be created or if any existing pure tones would be made worse. And the answer was no for both of those.
Okay. If a pure tone were discovered after project completion, what would be ways of mitigating or eliminating it?
If it was caused by something such as a fan, the fan speeds could be adjusted to a different frequency to make it higher or lower pitched, essentially, and help smooth out that sound level. There's a variety of different ways, depending on what source is causing the tone to occur, that could be implemented.
Okay, so it sounds like fans would be a significant, or are a source of pure tones, and that would be one form of mitigation. Are there any other sources of pure tones that you could point to and ways of mitigating them?
No, that's probably the best example I can provide.
Thank you very much. I will now pass it to... One moment, please.
Yes, thanks.
I will now pass it to Attorney Sharkey.
I believe the questions related to the stormwater plan design were already asked this morning. If that's what you're thinking, I might move to next.
Yes. So in that case,
Well, we have I have additional stormwater questions.
Yes, indeed.
But there were a couple of questions that had your name on it, but if you've already asked those questions, then we can continue on.
I believe I asked them this morning in
Okay.
initial discussions with the company.
Okay. Then I will continue on with some questions, stormwater questions. Okay, refer to the petition at 3. And again, I think before we go any further, we realize that since the petition, there's been 2 iterations of stormwater plans. So I think it would probably be most expedient to answer it based on the latest stormwater management plan that was submitted last Friday. We don't really need to know what's no longer proposed. We just want to go with what's proposed as of last Friday afternoon.
Understood. Thank you.
Okay. How would the stormwater system, as this is, well, I say refer to the petition at 3, but I don't think that's true anymore. It's whatever however it's covered in the latest. And again, we'll have more specific questions later on once we've had a chance to go through that this week and early next week. How would the stormwater system as proposed protect the Zone 2 wellhead protection area from just steady state pollution such as vehicle exhaust or spillage or from contaminated firewater suppressants during emergency operations? In other words, how does the stormwater system protect from contaminants going into the stormwater system, either in steady state operational mode or in emergency response mode?
So Frank Holmes with Langen Engineering. So to answer the first part of the question with regard to steady state, and I take it that you mean just during normal operation.
Yes.
Right. Yeah. So during normal operation, there really are very little, or there really is very little in the way of pollutants. It's a site there's not a lot of activity here from a day-to-day basis. It's, the occasional, maintenance vehicles or, facilities, maintenance, personnel, et cetera, that would be, entering the site in vehicles and, driving on the paved driveways on the property. And in that regard, the site's stormwater system is designed in accordance with the DEP stormwater management standards with regard to water quality. We have a number of best management practices that both meet and exceed the Massachusetts stormwater management standards, as well as the town's own stormwater requirements. So the drainage inlets on site are water quality separators, proprietary separators that are designed to capture total suspended solids, as well as petroleum pollutants like oil drippings and the like, from vehicles. And that pre-treatment is provided, and those pollutants captured in the water quality units prior to the stormwater being discharged to the subsurface tension and infiltration systems, which infiltrate the water into the ground and provide water quality volume in them to capture first flush, which then further removes pollutants.
Can I Okay, well, I'm sorry, continue on. I've got some
Yeah,
follow-up.
and I
Please continue.
just want to note that all of that in the proposed condition is, significant improvement over the existing conditions, which does not have best management practices as I just described. Essentially is just collecting the stormwater and piping it off to the town's municipal system with really no water quality treatment, no provision for groundwater recharge. And so it's a significant improvement over the existing conditions.
The pre-treatment, I'm sorry, go ahead. I'm sorry, I didn't realize that.
Yeah, no, so I realized I didn't answer the second part of the question, which is about during a spill or an emergency response.
Yes.
And so in that regard, the operation of the site will, include spill prevention and control countermeasure plan. That will be consistent with all applicable regulations, including federal regulations, as well as the mass contingency plan. So in a response to a spill, there'll be measures outlined in the spill in the SPCC plan that will include a site-specific safety plan and an emergency response plan. So there'll be an emergency response manager that will assess any kind of emergency and determine whether there's any response needed. In the event of any kind of identified release, then there'll be other measures that will be taken in accordance with the mass contingency plan to address any potential releases.
Okay. A few follow-ups then. Can you describe in the 10,000-foot view exactly what does constitute pre-treatment and what constitutes treatment in your stormwater system?
Yeah, so the pre-treatment in our system, the pre-treatment is
in the proposed
water
system. Yeah.
Wait, I'm sorry, I didn't hear what you said. So in our system, the pre-treatment?
In our system, the pre-treatment consists of the water quality units, which are designed to capture total suspended solids and floatables, like oil and gas drippings that are typical, from vehicles. So, there's below grade structures that would look like a manhole or a precast structure, maybe 4 to 5 feet in diameter, and they're designed to create a swirling motion of the incoming water that precipitates the settlement of total suspended solids and the capture of them, within the structure. And they also include essentially a hood or another type of device that captures floatables on the surface of the water, so that only the clear water or treated water exits the system. So that's the pre-treatment is designed to capture the majority of the pollutants. And that pre-treatment is provided before the discharge to the underground chambers, which then do, provide additional treatment as the water is infiltrated into the ground. It's filtered through the soil, and that provides, further treatment of the stormwater.
I see. And the pre-treatment is in essence a passive design that basically is kind of gravimetric. It settles out the solids, and there's some widget you have that collects the floatables. Is that correct? There aren't moving parts, in other words.
There's no mechanical That's correct.
Okay.
It's basically a gravity type of system.
Right. And the treatment then you're saying is passive filtration through the soil matrix. Is that correct?
Correct.
Okay. Okay. Do you foresee any situation where you'd want to turn off treatment basically, and instead of it filtering down, and then for some reason, I don't know, you have some pollutant load, something, I don't know, there, someone spills something on the ground and it goes into the stormwater system. It's an accident. Accidents. I come from working on spills for 35 years, and I know that accidents happen. So someone, I don't know, a transformer oil or something goes into the stormwater system. Do you see a situation where you turn off treatment? In other words, i.e., you might do pre-treatment, but then it doesn't percolate through the soil and it gets pumped out by like a pump truck. Do you see that situation or not really?
Not typically. The water quality structures that we have are designed to capture an incident similar to what you described, like say a release of oil. The water quality units are going to capture those, but the response to any specific release would be assessed at the time as to the proper way to address whatever the release is.
I see. So, okay. So more specifically then, could you, the way that it's designed right now, could you, I don't know, flick a switch of something and stop the fluid from percolating? Could you do that if you wanted to? Let's just say, just a hypothetical.
Yeah, and the system as we have it designed, there is no means for shutting the flow of the water off. However, as I mentioned, most pollutants are going to be captured in the water quality structures,
okay,
and then those could be pumped out. And that would be an appropriate response to a spill. It would be to, if there were a release of oil, like you mentioned, would be to pump out the structure to remove that from the water quality structure.
Okay. Thank you. The decision of the city relative to the initial, I recall Mr. Wren saying that the initial design was to actually pump the elutrate into the city sewerage system, but the city said no to that. And so now you have this revised system, which is reasonable. Did that come with a major cost increase to the project, or was that really not did that really add serious cost to this project, or not really?
I can't speak to the amount of the cost, but the answer is yes. The stormwater infiltration and detention systems did need to be redesigned to be larger than they were with the original design. And so in that respect, yes, it is more expensive, but I don't have a comparison of what that value is.
Okay, great. Thank you. I want to talk a little bit now about the treatment vis-a-vis the stormwater system of after, for example, an emergency like a fire. You described some things a little bit in attachment B from November 5th at 2, though again, I realize that's all changed as of February 6th. So I don't know if that really even matters at this point, that reference. are there situations where chemical fire suppressants may be used? And I realize I'm getting to this stormwater in a second, but would there be a situation where even basic fire suppressants might be used? I realize not necessarily on the burning battery units themselves, but around other buildings and nearby.
Sean Morse, the SRG. The short answer is no. We don't indicate or train in the ERP for the fire department to apply even water, generally speaking, but definitely not any foam agents or any inherent suppression agents. The only instance would be in a balance of systems or another fire on the site.
I'm sorry, the only instance would be in what system?
Another part of the system, so non-battery related, say a regular electrical fire in a cabinet on the site that you would have similar to another infrastructure site. You may use a dry chemical extinguisher that you find in ordinary industrial occupancies of a very small volume.
Okay, all right. Good. Regarding the efficacy of treatment, in EFSB W7, there's a statement that says typically pollutants would be the result of vehicular traffic. And the question is explain what you mean by pollutants would be the result of vehicular traffic. What does that statement mean? Do you mean emissions on sediment and sediment runoff? Is that what you mean? Or what do you mean by that?
So, as mentioned, previously in the sort of the normal operations or the steady state, pollutants on site are really expected to be from vehicles. So there could be oil drippings, grease, et cetera, that brake dust, other pollutants that are carried onto the site on tires. It's your typical pollutants associated with vehicular traffic.
Okay. My last question for now really is not about the stormwater system. It's just a general question. I'm not sure how it got in here, and was written in the last week for a very obvious reason as I read the question. Refer to EFSB S74. Would there be precautions to ensure that on-site facilities are not damaged during snow removal? We've had a lot of snow lately, and this is not Charlottesville. Let's just say that. Okay.
Hey, to be fair, we've had a lot of snow in the last 2 weeks.
Oh, you have? Oh, okay. All right.
Schools are closed for about 7 days.
Well, maybe this is more like
snow removal.
Maybe this is more like Charlottesville than I know, but I know I have a long driveway and things get damaged all the time by snow removal that I hire. So you have some really expensive, important equipment there. And what precautions do you foresee? Because where this is, Tewksbury gets a lot of snow at times. So how are you going to deal with that?
Yeah, so during operations, we would develop, or prior to operations, we would develop a snow removal plan that would be approved by this town. That would consist of snow blowing, trucks, snow plows, things like that. And then in terms of mitigating any sort of accidents or things like that, that would be part of the snow removal plan, as well as our health and safety team that would work with the contractors to kind of make sure they understand their role and their job, and make sure they understand all the safety components. But also, I don't believe it's in the site plan today, but certainly as design is further developed, bollards and kind of physical protection around.
I'm sorry, I just couldn't hear you. As the design is further developed,
bollards and other physical protection engineering could be added to the site as as seen as necessary, whether it's on like corner units to protect from turning, or edge units of the facility to protect against plows and things like that. It's also, there's a separation from the road itself and the batteries, and the batteries are not sitting on the very edge of the roads that would need to be plowed and cleared.
Okay, well, and in fact, I'm glad that you just brought that up, because I think the more to the point question is, if, God forbid, there was some issue at this facility someday, and it was, of course, I've worked a lot of emergency response. It always seems like when it rains, it pours. If we have a major snow event, and then there needs to be access to, some of these units, how do you see that working? Because I mean, snow can really pile up here. So how do you see that working?
Yeah, so that'll be addressed in the ERP, kind of how the snow removal plan works with emergency response. Sean can probably speak to this better than I can as well, but we also don't anticipate firefighters going immediately next to affected cabinets in the case of an emergency. But Sean, if you want to.
Yeah, Sean Morris, where the ERP states for an emergency on site, such as a fire or an off-gassing event, the fire department's role is defensive in nature. They are encouraged and trained not to enter the site, with the very rare exception that has yet to happen in the United States of a savable life being in or near these enclosures. Apart from that, they are to keep a standoff distance and await facilities and subject matter experts to assist with de-energizing. Sorry. These systems, as designed, are the intent is in a fire event for them to not propagate from one unit to the next, to stay contained to the point of origin without any intervention from the fire department or other responders.
Is there any reason, should rephrase this, phrase this. The units themselves sort of just work autonomously. So you really could have snow around them without having to shovel it out right away, couldn't you? I mean, because there's really no reason to, unless there's a problem, there's no reason to access these units. Is that correct?
When we develop our emergency response plans, we do try and be all comprehensive. So something such as a maintenance worker breaking his ankle and requiring EMS assistance on the site. So we still do encourage active snow removal and access for all types of emergency forces. But in the worst case scenario of a fire event would be the least likely where we would want emergency forces near these units.
Thank you. That's very, very helpful and enlightening. Mr. Strasberg.
If I can interject for a moment, does the company have a plan, or does it need to have a plan that addresses the buildup of snow and potential related snow melt on the roof of the modules?
Yeah, so the modules themselves are weather rated in terms of the IP standards. I believe they're called IP55. So they are weather sealed. They also will be monitored for snow accumulation, and all of the kind of vent systems are manufactured and built with snow and ice kind of in mind, and are certified to operate in winter and cold conditions. Yeah, but again, I think that'll be more robustly addressed in the snow and ice management and removal plan developed prior to construction.
Thank you.
Just one moment, please. Thanks. Please refer to the company's response to EFSB W3. And this is in regard to the hydrogeological analysis. And I'll start off just by asking, when can we expect that analysis?
So we're currently working on that and expect to have it by end of week.
Can you repeat that?
We're currently working on the study and expect to have it available by the end of this week.
Okay, thank you. All right, let's move on then to the topic of BVW impact. And I'll read two quotes. The first is from the initial petition at 22, page 22. Construction of the proposed transmission interconnection will result in the temporary impact to approximately 2,400 square feet of BVW. So that's the first quote. And the second comes from intervener's witness Scott Horsley's pre-filed testimony at page 7, and that's exhibit SD-SW. And that says, the post-development plan is to infiltrate most of the rainfall and stormwater on site and to direct any overflows to the bordering vegetated wetland to the west of the site. This will result in significantly higher groundwater levels with the wetland. So with respect to that, I'd like to ask you, describe the temporary impacts to the approximately 2,400 square feet of BVW.
This is Mark Bergeron. I will talk about what we've proposed for impacts. We believe the impacts would be 2,400 square feet of BVW impact is associated with the area of underground installation from Power Company Road up to the point of interconnection at the Tewksbury substation. So if you'll give me a minute, I can actually show you where this is graphically for perspective.
Of course.
If you look at figure 2-3 in the petition, page 6.
In the initial petition?
That's correct. Page 6, figure 2-3.
One moment, please. Okay, figure 2-3, I'm there.
Great. The dashed purple line coming from the project site going north across the MBTA right of way, then making a left-hand turn to the west. Do you see that line?
I see a dashed blue line and I see a dashed light blue line.
Okay, yeah, it may just look like that in your copy.
Yeah, that's fine.
You see in the legend where it says transmission line interconnection route, that's the dashed line that you're looking at.
Yes.
So if you see where that takes a turn to the left or to the west and goes towards the National Grid Tewksbury number 22 substation, you will see then it takes a sharp turn to the north into the substation itself, where it crosses a green area that is a bordering vegetated wetland. Do you see that area?
Yes, I do.
That National Grid has told the company that they need to connect or come in with their interconnection on that side of the substation.
Oh.
So the underground portion of that will need to be installed through that wetland system open trenched. So the 2,400 square feet of temporary impact is associated with the installation of that. I believe it's approximately 400 linear feet of underground line through that wetland system.
Okay. Do you concur with Scott Horsley's conclusion then that this will ultimately result in significantly higher groundwater levels within the wetland temporarily and/or permanently?
My understanding of Mr. Horsley's testimony is related to the bordering vegetated wetland to the west of the project site. So it's a different area that he's referring to, and I will let Mr. Holmes speak to the effects of that area. I believe Mr. Horsley is contending that we won't have direct alteration, that's physical alteration, but that our way our stormwater system is designed would result in some alterations to groundwater, and I will let Mr. Holmes speak to that.
Yes, Frank Holmes, with regard to Mr. Horsley's analysis, you performed a hand-touche method analysis of the precipitation falling on the site on an annual basis. I have not seen hand-touche method used in that way or to analyze a site, but his analysis assumes that flow is happening in a constant rate over the entire calendar year, and I don't believe that that's representative. The way precipitation events happen, we have a small rain event, might be several days that pass. We have another rain event that may be larger. We have large storm events. So they happen intermittently throughout the course of the year, and his analysis assumes we have a steady flow of groundwater that represents the average that's going to fall from the sky over the course of the year, constantly infiltrating into the ground. And I don't think that that's representative of what happens in reality.
If I could also, excuse me, add, this is Mark Bergeron. My experience has been with regards to alteration to bordering vegetated wetlands or any type of vegetated wetlands from a stormwater system. The presumption is if the stormwater system for a proposed action has been designed in accordance with the Mass DEP stormwater standards, which consider water quality and infiltration, the presumption is you're not going to impact groundwater to the point where it's going to have a detrimental or adverse effect on adjacent wetland resource areas.
At some point.
Yeah.
At some point.
Would you like to know?
Yeah, if that's okay.
Yeah.
If I could follow up for just a moment with Mr. Bergeron's comments about the interconnection line that goes to I guess it looks like the southeast corner of the substation number 22. It takes that hard right going north into the substation. And this is just an example of BVW impacts, but the question is for things like wetland and in this case, BVW impacts, temporary, what is the company proposing for post-construction restoration and remediation?
In this instance, it's an underground installation that would require open trenching in this case, given the geometry. So when you open cut a wetland system, whether it's for an underground duct bank system, a gas pipeline, the construction methods are actually the mitigation methods. So what will happen is the top layer of soil, which is the organic material, is segregated and placed aside. And then the underground facility is then put into place underground. There are then bentonite plugs put in on either side of that trenching to ensure that, water doesn't come down act as a conduit and escape from that wetland system. So you essentially restore the hydrology, and then you place that top soil that you had set aside, the organic soil, back onto the top so that what was on top prior is there now. It will also be an assessment after that by a professional scientist to identify if any additional supplements are needed as far as organic soil. Sometimes there's some settling. We want to return elevation. And then we will also look at natural recruitment. You have seed stock, such as ferns and other native vegetation that are still in that soil that will tend to just revegetate naturally. Typically, when we're dealing with this type of impact, the Conservation Commission, who we will be in front of to get an order of conditions for this project, will require, or the company could propose, a 1-year monitoring period where if the area hasn't revegetated, it could be seeded with a wetland seed mix.
Okay, so, and you mentioned the Tewksbury Concom, which makes perfect sense. So are you holding off on any kind of detailed mitigation plan until you get the order of conditions from the Tewksbury Concom? Is that sort of the game plan?
No, not necessarily. Our notice of intent application would require that we provide some of those details. In this type of proceeding in front of the siting board, we don't typically provide that level of detail for those specific things, but we are going to be required to do so as part of our notice of intent filing under the Wetlands Protection Act. It's very wetlands bylaw.
Sure. Makes sense. Thank you. Thanks.
Thanks, Mr. Riley. I'd like to stay on Mr. Horsley's pre-filed testimony, and this time I'd like to go to page 4. And here we do have a quote about that hand touche model that you had mentioned. The applicant, and I'll read it, the applicant has provided groundwater mounding analyses using the hand touche model for infiltration systems, B1, B4, and B5. However, the analyses are limited to short durations of 0.34 days or 8.2 hours, 0.45 days or 10.8 hours, and 0.45 days, 10.8 hours, respectively. Their analysis is focused only on the short-term hydraulics of the system. They have not modeled the impacts of the full 24-hour design storms, 10, 25, 50, and 100-year, as required by the Mass DEP Stormwater Handbook. Can you explain why these particular durations were chosen?
Yes, I can. So again, Frank Holmes. Those durations are the drawdown time that is included in our calculations for the recharge systems. So one of the DEP stormwater management standards is for providing groundwater recharge, and part of that analysis is a calculation of the time that the prescribed recharge volume takes to drain out of the system. And that standard also requires an analysis to demonstrate that the recharge volume will drain within 24 hours as part of the mounding calculations. And so, our hand touche method calculations for the mounding do what we believe the standards require, right? Which is to demonstrate that the recharge volume will drain within 72 hours without creating a mound that encroaches into the bottom of the recharge system itself.
Okay. So in terms of these durations and the data that's collected through them, can you just elaborate on why they provide a sufficient picture in the context of the full 24-hour design storms?
Yes, yes. So I want to start by describing my understanding of the purpose, for needing the mounting analysis and the standards requirements for performing a mounting analysis is part of answering the question. So a mounting analysis is required when you have less than 4 feet separation to estimated seasonal high groundwater in the bottom of a recharge system that is used to attenuate peak rates of runoff. And in our design, we did have that condition where we do have less than 4 feet separation to groundwater, and our calculations were assuming infiltration through the bottom of those systems for demonstrating compliance with standard 2, which is peak rates of runoff from the property. And so the intent of the mounting analysis is to show that for your normal, typical rainfall events that you have, where you're going to be capturing your recharge volume, that can drain within 72 hours after the storm, and that you're not creating a groundwater mound that encroaches into that infiltration system, so that when you do have a larger storm event, a 2-year storm, up to a 100-year storm, that volume in your system is all available, and that you are going to be able to infiltrate through the bottom of it if your calculations assume or if your calculations rely, I should say, on infiltration as part of your compliance with the peak rate of runoff standard. So I have something to add also, but I just want to, is that clear, or can I clarify that if it's not?
That is clear.
Okay.
So this isn't really an issue if you had sandy soil, right? If you were on the Cape, you don't really have a mounding situation because the transmissivity is so high. But if you have like really clay-based soils where the transmissivity, hydrogeologic transmissivity is real low because it's clay, then that becomes a much bigger issue in a place like that. Would that be correct? Where mounding becomes a bigger question.
I think generally that is correct, yes. Okay. I'd also like to add that the calculations that were submitted this past Friday remove the credit for infiltration from our HydroCAD model, which is how we demonstrate compliance with standard 2. So we are, in these revised calculations, we are not relying on infiltration for compliance with standard 2. And therefore, we suggest that the mounting analysis is not required. And the requirement for a mounting analysis is an and condition when you have less than 4 feet separation of groundwater and your recharge systems are infiltrating for compliance with standard 2. So in other words, our recharge systems could be watertight and with no infiltration, and we would still meet standard 2.
We'll be asking more questions about that probably in a later day.
Okay, so all of that is quite clear. I just want to have you just speak to another piece of Mr. Horsley's pre-file testimony at 8. And again, it goes into this to an aspect of this, but I'd like to hear your thoughts about it. The quote is as follows. Annual rainfall in Tewksbury is estimated at 44 inches per year. Assuming an abstraction rate of 10%, this results in annual net rainfall that is infiltrated to the subsurface of 40 inches per year. This represents significant net increase in on-site recharge of 1,649 cubic feet per day. Apply this recharge over the high infiltration areas, 4.145 acres results in a groundwater rise of 1 foot to 1.4 feet across the project site. And within the adjacent bordering vegetated wetland, do you concur with this conclusion? What is your response to this conclusion, please?
So as I mentioned earlier, this analysis is assuming that all of the rainfall that occurs annually is averaged out to be 1,649 cubic feet per day at a constant rate. Every day that much water going into the ground. And Mr. Horsley performed a hand-touch analysis that analyzes a groundwater mound that would result in that condition. But that's really, I don't feel is representative of how the precipitation is happening during a storm. So I think that I disagree with how the analysis was performed.
Okay, thank you. I do want to stay again on Mr. Horsley's pre-file testimony, but this is a somewhat different topic. And this is actually the supplement to the pre-file testimony. And so the exhibit is SD-SW parens S1. And I'm going to read out the quote. And it's as follows. The alternative layout also includes a mass DEP requirement for a containment system that could capture hazardous materials that could result from a fire and subsequent washdown to extinguish the fire. The impervious surface could contain fire-related wash water by closing a shutoff valve prior to the vegetated stormwater treatment systems, thereby allowing for a subsequent pump out. And the question I would ask with respect to this is, can you please compare this proposed containment system, this containment system concept, with the project's containment system in terms of containment capabilities and amount of impervious surface?
So first, I'd like to note that I don't believe it is a DEP requirement for an impervious containment system, as Mr. Horsley is suggesting here. What he's suggesting is different from our system, in that what he's proposing is that all stormwater, all firefighting water would all be contained in an impervious area that could be pumped out, where our system consists of, as I've previously described, water quality units that provide pretreatment with an overflow into chambers below grade that provide further treatment, in which our water quality units could also be pumped out.
Okay, thank you. I will hand it off to Tim. Mr. Riley, please.
Thank you, Mr. Strasburg. Well, we said we were going to ask about some of your revise from last Friday later. Later has just happened, and here we are. Okay. 1 second. It's funny, it doesn't have a number to it, but that's okay.
You got it?
I do. Refer to the cover letter of Eben, is that a correct pronunciation? Albert?
That is correct.
Hi, Evan.
Hello.
Regarding EFSB 2508, filed on the afternoon of Friday, February 6th. The letter states, enclosed for filing, please find a revised stormwater management memorandum from Langen.
I'm
labeled as-
sorry, I couldn't understand you. The letter
Oh.
states what?
Enclosed for filing, please find a revised stormwater management memorandum from Langen, parenthesis, labeled as attachment B, second supplemental, end parenthesis, period. The stormwater management calculations submitted in the previous stormwater report assumed infiltration within the HydroCAD model to demonstrate compliance with Mass DEP Stormwater Standard 2 peak rate attenuation. The company's stormwater consultants at Langen made a minor modification to the design, and as a result, infiltration is not required to control the peak rate of runoff. Because infiltration is not required to control the peak rate, a mounding analysis is no longer required to comply with the Mass DEP standards. And I'm still, I need to read this more because it did come in late on Friday. This is sort of a cursory sweep at this. We'll probably go into this in greater detail next week. Or the week after. Describe how the questions are, describe how the stormwater management, and this is at a 50 to 100,000 foot view for now. Describe how the stormwater management system has materially changed relative to the December 2025 stormwater management plan. How has it changed? What are the material changes to this plan?
Frank Holmes, the material changes are very minor. The size of the underground detention and infiltration systems did not change at all. The elevations and configuration of the outlet control pipes were adjusted in order to demonstrate compliance with standard 2 peak rates of runoff. So that the changes are really limited to that, and I would say they are relatively minor and immaterial.
Okay. How do these material changes affect the following? Stormwater infiltration rates.
Not material.
Groundwater recharge rates.
Not material.
Stormwater pretreatment.
Not material.
Stormwater treatment.
Not material.
Okay. And I'm sorry, it might just be that I haven't had my afternoon coffee, but I'm a little slow at a couple of things you were saying earlier. Can you one more time describe in layman's terms sort of what is happening with this mounding? You're saying that there isn't mounding. Is that what you're saying? Are you saying that it's just sort of spreading out and this is no longer a mounding issue? I'm just trying to understand mechanistically what you are saying. So take me through. Water comes in the rain, precipitation comes into the ground, and there's an aquifer, and there has been some concern with mounding, but you're saying that there isn't a concern. Why? Why are you saying that?
Sorry, just a moment. I have a minor emergency. Could I have 2 minutes, please?
Oh, sure.
Absolutely.
Thank
Off the
you.
record.
Please forgive me. Can we have 10 minutes, please?
Oh, sure.
I have
And
I have an emergency going on here.
sure, go ahead. Take what
Thank you.
time you need, Alan.
Thank you.
Donna?
Yep.
It being 3:50 and we are pretty much at the end of the day, I would think, because we're starting safety
Yes.
next.
My expectation is that, if we can, we'll finish up. If Alan can't, then we'll finish this up tomorrow morning and then launch into safety after that.
Right. Yeah. I just don't want to squeeze poor Alan here.
No, I know, exactly. Plus it's,
So,
a
we
long
went from
day.
2 minutes to 10 minutes, and I'm kind of thinking that since, we're just about there anyway, I kind of wonder if we should, I mean, we can give 10 minutes if I have no problem with that, but I do kind of wonder maybe we should just let this go for today. It's up to you.
Yeah,
Obviously.
that's fine. I'll just talk to Alan on the phone and he'll put in that we went off the record in the transcript and we'll resume tomorrow at 10.
Right. And quite frankly, I would kind of like that too, because I would like to read a little bit more about their 2/6/26 submittal, as well as a couple other things so that I can ask better questions. Because quite frankly, I think the line of question I'm asking right now could use a little bit more homework just because this stuff came in so late.
Sure. And again, a reminder, I guess, to everybody that with with materials that have been coming in the last few days, last week, there will be opportunities to address that later in the record. People
Oh.
should feel free to ask questions now and to kind of become comfortable with what they can for the materials, but there will be the opportunity to later address, when people have had sufficient time to review the materials, questions related to those materials.
Very, very good. So with that in mind, I have no further questions right now.
Okay.
Do you?
What I have can wait till tomorrow.
We're off the record anyway, but is there anything anyone needs to raise while we're off the record related to tomorrow?
That, I think you're picking up tomorrow where we just left off with the question for Mr. Holmes, right?
That's right.
Yeah, okay. We're all set. Hope Alan is okay.
Yep, I hope so. I'll text Alan and he can wrap it up.
Actually,
Forgive me. There's an emergency in my building. I've got to deal with this right now.
We're gonna just go off the record and we'll start tomorrow at 10, Alan. I appreciate everything
great.
you've been trying to do.
Very sorry.
No problem.
Okay.
No problem.
Good luck with everything.
Thank you.
Okay. Good night, everyone.
Night. Thank you.
Thank you.
Thank you, everybody.
Thank you.
Thank you.